she's stupid. First off, that is exactly what you would take judicial notice of, court records. Halfway through the 20th page. It's going better than I thought it was going to be. Taste the Rockies. Oh, there goes the cap. I don't want to kill you. Do you feel in charge? No, brother. They expect to find a body. Rock, flag, and eagle. Red eyes, black eyes like a doll's eyes. Don't seem to be living till they bite you. Those multi-syllable words were difficult at the end. Throw a little chaos in the mix. This unsung hero of Gotham. Can't rob the stock exchange. There's no money here. Why are all you people here? We're going mobile. All right, let's go. Hello, everyone. How are you?
Hi.
Hi, Suma.
Hi.
Welcome back to part 2. Thank you, everyone who's here. I know SKR's got a video premiering right now, but unlike SKR, my sound is synced on my video.
Not to get ugly, right?
No, I feel his pain because I've had that several times, and it's always the last thing you do that you change, and then you think it's not going to matter. You're just fixing one little thing, and it. Oh, nice, Meowgarita.
Oh, clef.
Wow. That is. Oops.
Meowsing.
Good.
Should have done this.
Meowgusta.
Meowgusta. Well, it's such an honor, Meowgarita, and I like it as well. Everyone should try and incorporate cat into their.
Hey, Gusta. Meow Gusta.
Meowgusta. What could Suma change to? Meow.
Yeah. Right. I mean, at least people wouldn't think it's something pornographic then, I guess.
It's maybe loud meowth. Loud.
Right. Yeah.
All right. So we finished off yesterday with part 1 and 2. We finished those, and part 3 we put up just for a second, but I don't think we played much of it other than the compound interest section. So we're going to start with just number 3 again. And we have part 4 as well. So I think there's about 45 minutes left of it. Yeah. Turns out a lot of the remaining hour that I had was a lot of me just doing impressions. And that's why. But, and everyone should know that I understand my impressions are bad. That's why I do them, because they're funny.
To Alimony under Florida law, in which the petitioner and his counsel.
Okay, so we're starting here. This is where she starts arguing that being in jail doesn't have any effect on alimony, which, spoiler alert, there is no case law that supports that. All the case law she says is the opposite of what she says. $1.99, not intentional. I want to change my hands. Fucking rod. Yes. So this whole section is irrelevant because of how long it is and how she doesn't address the main point. That they're saying incarceration changes your situation to no longer need alimony. She doesn't ever address that at all, other than to say they're not they're changing the argument somehow. But I'll comment on that when we get to it. We'll hiccup there. Did you have anything you want to say before we start?
No.
Okay.
Thank you, Meowgarita, about the lipstick. That's all.
Yes, I did notice you were wearing lipstick as well, but I didn't want to say anything because I didn't know if that was socially acceptable.
Yeah, I didn't ask you how it looked either, because I was like, we don't have to have these kind of discussions.
Respondent maintains that incarceration should not justify ending or reducing her lawful entitlement to alimony under Florida law, in which the petitioner and his counsel have been using as a means to deny her access to justice. The petitioner fails to demonstrate any substantial
No, Sarah, you are denied access to justice by the fact that you don't have any money. Just because your husband won't pay for the lawyer to get money from him does not mean you don't have access to justice. Everyone has the same access to justice.
She has too much access to justice.
Yeah, she has too much access to justice. Yeah.
Change in circumstances by refusing to submit requested financial documents to the respondent in court to prove otherwise. Tax returns foremost, which would identify past employers he is claiming to not have had.
One other thing, I called out 1-2 yesterday. Turns out that's a different 1-2. He replied, he goes like, no, I'm not the same person. So apologies, 1-2. It was just timing coincidence of when you left your first comment and 1-2 had showed up earlier in that same stream. So
he did. I thought he had a name like that, but I don't know.
Well, it was 1 with the number 2. His name, the guy in the comments, is just 1-2, like 2 words.
I see.
Or any other forms of income. He also has committed perjury to the court by submitting untrue documents such as his financial affidavit, which does not match up to his regular spending habits, alcohol, cigarettes, video games, entertainment, travel, etc. Income from his family, $50,000 plus a year, excess of selling the marital home, $200,000, and more, while supporting a child and being supposedly, quote, unemployed, with no means to comply and pay his alimony obligation to the respondent as ordered. Respondent requests the court to compel petitioner to 1. Provide reasons for his underemployment for over three years to present with having the ability to work, and explain to the court how it is not deliberate.
Yeah, we got a lot of information here. So, first off, I was under the impression that the house was foreclosed on. It wasn't sold. I can double check that here. But so I don't know what she's talking about, the $200,000. Just whatever.
Well, I think that he may have, when she left the home, he may have had supposed to give her money for part of the home if it was purchased when they were married already.
Maybe.
I mean, that's what they do here. I don't know.
Let me just see Brian Boone. Yeah, it went into foreclosure. So he didn't sell it for a bunch of money for $200,000. I'm thinking she probably just doesn't believe.
Yeah, maybe
that it was the foreclosure because, Brian's parents would never let that happen or whatever.
No, she doesn't believe it because it doesn't behoove her. That's all. She doesn't believe anything because she's always lying.
Yeah, because she lies, she assumes everyone else is lying. She has no proof of any of the income from family, right? It's not income from family if they're just buying you stuff. That's not income. You're not paying tax on it. Income is taxable, which is why it's not on his tax return. This is really what bothers me. Her stupidity with the
everything.
Misunderstanding the most simple concepts.
Yeah, and she talks about how she's a tax-paying American. I guarantee you, she has not paid taxes. Certainly not since being incarcerated, because that doesn't apply to her. But she's supposed to, I would imagine. I don't know, and it
varies by state.
Okay, and I bet the first 2 years or whatever, when she was out in the wild, she wasn't paying taxes on her alimony, which she is also obligated to do.
Right, she's obligated to do that. Like the payer is
guaranteed she didn't, unless he took care of it for her.
It had gone through foreclosure a couple times, but he got out of the foreclosure and sold it, I thought. Oh, okay. Then he must have sold it. When did he move? He moved to Gainesville in 2023, right? That's from the timing of her letters. Okay, that makes sense. But just based on his history, I'm not going to put his business out there, right? But he's not swimming in money based on the paperwork out there. And she hasn't worked at all either.
Sarah saying his parents are wealthy have money means absolutely nothing. I mean, there's one thing I can't stand is people who decide how much money other people have and what they should do with it.
They have 4 homes. 4.
Yeah, first of all, it says you, and also, so what? Maybe they rent them out. Maybe they're, who cares?
Yeah, Katie's right as well. She was bought out, so it's not her house at all.
Right, exactly.
And you don't just take the money and put it in the bank.
And where's that money?
He bought a new home, right?
No, I mean that he bought her out with. That went straight to Publix.
Oh, yeah.
Yes.
Well, they used to be able to afford vodka, but then they had to change to wine, right?
Vodka for two people to have a really good time.
A really good time. Really, really good time.
Now, every time my best friend gets something for like we're meeting up, whatever, she's like, well, I got enough for two people to have a really good time. Like, we'll see about that.
Yeah, okay.
2. Explain to the court his livelihood income while...
Speaking of the financial affidavit not matching his regular spending habits, neither does hers.
Well, I'll say.
She puts zero income, but then she has expenses. So where's the money coming from, Sarah?
Brian. Someone has to call Brian.
And she well, I don't want to jump ahead to that part, but
quote, unemployed and supporting the minor child for over 3.
Let's just say she makes the dumbest argument ever, and she doesn't even realize she's doing it when she gets to that point, when she's talking about the money that Brian gave while she was in there in regards to alimony. Do you remember that section? It's near the end. But basically this won't really spoil it, but she's trying to make the argument that all the money that he put on her books in credits up until now shouldn't count towards what he owes in alimony. Because those were just gifts, right? Those, which is incredibly stupid for her to do. From her standpoint.
She called 911 and says someone just bought that George stole the bike she bought for him as a gift. So I know that's not what you're referring to.
No, I got you. Yeah, but she thinks it makes it so she'll get more money, but
yeah, that was very stupid because it shows that he's been giving her money.
It shows that he's been giving her money, but it also she's trying to make the lawyer. Well, I guess we'll just talk about it. His lawyer made the argument that it is money that was given to her, but it wasn't alimony, right? Because the reason, now it might not sound, not saying technical, right? But if, for instance, if you have a credit card that somebody opens somewhere and you never make a payment on it, right? Mm-hmm. Once you make a payment, that validates the debt because you go, okay, yeah, this is my debt that I owe, right? Versus if you never make a payment, you could say, I never acknowledge this debt. But as soon as you make a payment, you're saying, yeah, okay, I get it. That's why I owe this money. So by her saying, no, I don't want it to count as alimony being paid, she is invalidating that he is acknowledging he owes the money by making payments towards an alimony source. So she's so stupid. Yeah. And she also said everywhere in text, I'm going to take it off of what is owed. But it's an incredibly stupid argument to make, and she doesn't even realize how stupid it is.
3 years ongoing. 3. Present any evidence of permission given by the court to reduce and terminate his obligation of alimony payments to the respondent. 4.
Well, if number 3 existed, we wouldn't be having this trial, would we, Sarah? It's what's going to be decided at this upcoming trial.
Specify the single reason for modification and why it was not determined and continued throughout the process of this matter to lawfully allow respondent to correctly identify and respond in her rightful defense.
Well, there's 2 things you have to respond to, Sarah. 1, he is saying he doesn't have the money, and 2 is saying he doesn't owe it. It doesn't mean that it's invalid because he's naming 2 reasons. He doesn't have to provide 1 reason, right? He can have more than 1 reason. They can both be valid.
I mean, God knows she has a lot of bunch of reasons for everything. And
she puts the cases she cites, the modification is always a reduction of the alimony. It's like from a permanent alimony to requirement needs, right? It's always a reduction. So it doesn't make any sense in her case. Like I don't know. I don't think she fully read.
She didn't. Whatever you're about to say.
Well, I don't think she fully read the cases, right? But even if she did, she doesn't understand them. She just sees alimony.
Yeah.
I feel like somebody else did the research for her because they don't know. Because if you read it, you wouldn't put it in
not
there.
Reading anything, I guarantee it.
Judge stated alimony in 2022 till it was known where Boone's forever will be. Yeah, and there can be. So the whole thing is, yes, the court didn't say you can stop, but there's remedies for that. If he's found to owe it, there will be back penalties and interest, right? That will, that would be part of the outcome of it. But it does not make sense to give money that you don't believe you owe to somebody that's going to spend it. And if he doesn't have the money either, I'm sure he would have put it in escrow if he had the money, because that would look better to the court. But I don't think he has any money. He's raising a single child, or he's a single father raising a child.
Yeah.
Just like childcare alone would be more than $1,000.
Whatever extra money he has, he should be spending on booze.
In addition, respondent respectfully requests 5.
And I don't understand why. Why break this up? Here's all your requests before. In addition, here's my additional requests.
Sanctioned petitioner and his counsel.
It was fine. I wasn't hungover. Why would I be hungover?
For their willful violations of the court orders of alimony payments to the respondent with active agreements and undermining its authority of consequences for their ongoing non-compliance. 6. Enforce original alimony obligation, regardless of respondent's current circumstances, in order petitioner to pay $62,000 as estimated and calculated, minus appropriate costs deemed just and ordered by the court.
Enforce original alimony obligation regardless of current circumstances. This is the most detached statement she could put in here. The whole thing is because circumstances have changed. I know her argument is nothing has changed, but like she's like something that occurs regularly is because circumstances have changed and orders are changed. Just so, I don't know.
62 months times $1,000 ordered payments per month equals A, including while located at OCCD without sentence.
Yes, we got another one. Look, see here. Yep. And just celebrate that. Look at this idiot.
In the trailer with him.
With open active court order.
Yeah, he never washes it. He claims he washes his bed like every day.
So those sheets are made out of like asbestos. Just everything is nasty there.
Yeah.
Ordered agreements. C. No judgment made to any modifications
proposed
by petitioner.
It takes a while to get it.
No permission granted to petitioner to reduce/terminate payments. E. No stipulations in any agreements regarding incarceration. 5 years.
Okay, no. So I pre-gamed the reading. So I wasn't drinking before yesterday's stream, Meowgarita. I pre-gamed before this whole reading that I'm doing, and then I had to edit it yesterday, and then I drank during the stream, and then I drank right now, right? But no, I mean, it was a little bit slow getting up yesterday morning. Not that bad, though.
Plus duration while located at OCCD to present equals 2020, 10 months, 2021, 12 months, 2022, 12 months, 2023, 12 months, 2024, 12 months, 2025, 4 months. Petitioner is basing on completion of his 84 ordered payments per agreement April, which is to date and obviously incomplete. 7. Hold petitioner
accountable. Obviously incomplete. Yeah. I was trying to find an online bingo that we could do with this.
Me too.
I found one, but I couldn't get the JSON thing to work.
I figure we'll figure it out. Maybe we'll do a separate, that'll be a fun thing to do, right? Or
yeah, it's I was trying to do it because this one is more difficult because it's not her just letter, right? She does a lot of the same kind of stuff, but I was thinking it would have to be items like ceaselessly and obviously incomplete, or but maybe like a catch.
Yeah.
Or a catch of like it has to be when the word isn't backed by evidence. So obviously when it's not obvious, incomplete when it's not complete. So like opposite use of the word. But yeah. So here she just quotes the interest. Okay, yeah. I won't step on it.
For the interest accrued on arrears as a matter of equity, law, and appropriate authority, calculated as follows per Florida law. Quote, Florida law imposes interest on unpaid.
Do you think she doesn't get paid at jail because her work pays for that $150 day per charge? Well, I don't think it's legal for them not to earn anything. It's like a couple cents or whatever, but I don't think you could legally force somebody to do something in prison without paying them even like the minimum amount.
Child support and alimony.
Or else it's called slavery.
And a statutory rate. As of July 1st, 2025, the interest rate for unpaid child support is set at 8.9% per year and may vary annually. Interest begins accruing on the overdue balance as soon as a payment is missed, and means the longer the arrears go unpaid, the higher the balance grows due to compounding interest. In many cases, interest can become a significant part of the arrears balance, so it's important to address unpaid support as soon as possible. 8.9% interest, Florida law, times 62 months, incarceration equals $5,518.
I mean, I hate to be the person to point this out, Sarah, but you're on. That's not how compounding interest is calculated. Plus, that's the interest rate for 2025. It wasn't the interest rate for prior years. Maybe this is just another math thing. Maybe it's just another accounting thing that I've just suffered through that thinks. I mean, she even put it in her explanation, compounding interest. Compounding interest means it's recalculated. If it's annual, right, then whatever the interest rate for 2020 was, you multiply the outstanding balance at the end of 2020 times the interest rate imputed. I don't know. Whatever it would have been. Let's say it was 5%. Okay, so let's say, I don't think the super duper book she got helped at all, because she's basically just copying the layout and format of the judge's pretrial statement order. She's borrowing a lot from Brian's attorney in terms of like the flowery language that she uses. It's not flowery when he uses it, but she, throws in like, it is obvious and inappropriate authority, blah, blah, blah. But yeah, 2020, you owe 10 months, $10,000, 5%. So you owe $500. So then 10,500 is the starting balance. Then at the end of 2021, when there's another 12,000 added on the unpaid payment, it's 22,500 times whatever the implied interest rate is. It's not 22. No, see, Miagarita, hello, Baba Gadoosh. When people give money to Brian, that's income. But when people give money to her, those are just gifts. Just like the money that she was given by Brian, that's not income to her. That is just a gift. But Brian obviously would not be receiving gifts from his parents. That is income. They send him a W-9 at the end of the year. 2,000 times that rate. That's what compounding interest is. On W-9. She's so stupid.
$5,518
you tell I hate taxes?
interest plus $62,000 arrears equals total owed by petitioner pre-deductions from the court of $67,518.
No, that's not what stopping in. What does that mean, Kelia? Where are you going? What do you have to do? Who are you talking to? Who's taking up all your time? If you have compounding interest, moron.
9. Respondent is requesting $300 to be deposited by the petitioner into her DOC inmate account on the first day of every month until debt is satisfied, or other arrangements have.
Is it Carter? Is it Rod? Is it Todd? Is it Will? Talk to me, Jamie.
Been made, and her request pending her appeal. 10. Dollar amounts from her financial affidavit needed for her son, such as communication, gifts for holidays, etc., will be billed accordingly from total amount owed, and is separate from monthly payments to her inmate account. Further arrangements can be made, if applicable, upon order of the court after formal judgment has been made concluding trial.
Not that this ever occurs to her, right? But a payment plan of $300 per month is incredibly stupid because there's a future value of money. There's inflation, right? So $300 today, for example, is not going to be the same as it is in 5 years, especially with the vendor price fluctuation she always complains about, right? So she should be arguing for lump sum, like saying whatever he's got to do, you've got to take out a loan or something, right? I want the lump sum up front in my account. But she could also be thinking maybe if she had all that money in there, she couldn't beg other people for money, right? If she only has $300 and it's eaten up, and she can't say, or she gets $67,000, she can't say, I only have $10 left for this month.
Yeah, she can. She can, and she would. She's not thinking that smart, I don't think.
Do you see what balance? If anyone knows this, Animal Crossing, you're all wrong. It's Donkey Kong. Let me comment on this in a second. Oh, okay, 300 is the max that can be in an inmate account at any time. Thank you, introverted giraffe. That piece of information was very helpful.
Now, Gusta.
See what we all learned here today together. I won't put that up there. The Animal Crossing, I think one of my favorite moments in a Lorne call is when he's sitting there pouting and Will is playing Animal Crossings in the background, and he keeps turning the volume louder and louder, the music. So it's just blasting loud. And he's like, I can't hear you. I can't. What? The music's too. Can you turn the music down? And he keeps moving it closer and closer. It's so good.
In conclusion, respondent is not requesting a
Baba, you heard that one, Baba Gadoosh? Do you remember which one it is? Because I can't remember the episode it's from. I know it's from a Sundays with Cod, but
new award of alimony based on her actual mate or circumstances, rather graciously asking the court to enforce the original order, which was/is active during her incarceration, without any stipulation of or permission to modify any part included. Additionally, respondent is asking court to hold petitioner accountable for the arrears and interest accrued due to actively violating compliance according to court orders and Florida law, justifiably upholding the respondent's constitutional rights and proper inclusion while seeing her good faith efforts and patiently cooperating in every manner possible, even under the added, quote, chaos.
See, there it is again. She hates that he put chaos in there. But this isn't constitutional rights, Sarah. There's no it does not say alimony in the Constitution.
Created by the petitioner through their perpetual unlawful attempts of advantageous gain and control of this case as a whole.
If they were really unlawful, I'm pretty sure his lawyer would be disbarred, which she almost basically asks for later in this letter, right? She doesn't come out and say it. She's just like, there should be heavy sanctions, which is rich. Her telling a lawyer what is legal and not legal. I don't know.
Yeah, well, that's how she does. I mean, she used to write Judge Cranick all the time about with legal definitions.
If they were unlawful attempts, how come we're having a trial, Sarah? I mean, when they just do it, like screw the justice system. What if they were unlawful? Why have a hearing? Why push to have a hearing that you didn't want to have?
That's what I mean. She doesn't understand anything.
Yeah, I think
it's impossible to understand how little she understands.
I think she just believes so much in her own ability to pull the wool over people's eyes, that she thinks she could just pretend like none of the stuff that led to this hearing happened, right? She could pretend like they excluded me, not I was trying to, or I was being as difficult as possible, right?
She doesn't understand anything.
Right. 50 hymnals. Yeah, she needs 50 hymnals. Where did all the extra money she got? Well, I think Kim, what Giraffe was saying was that the balance can't exceed 300. So if you get 300 in there, I spend $100 a day, that could be topped up at any time. Yeah.
Right.
The petitioner's bad faith also automatically assuming their success in overruling the court and taking advantage of the disadvantaged respondent by implementing their rules of not paying or cooperating with anyone should not be rewarded, were removed and made known to all parties. Authority belongs solely to the court, and orders are given for reasons of justice, formally, legally, and constitutionally.
Oh my God, her hyperbole with this stuff, like she's acting like this is a groundbreaking, like
Yes.
This is going to go all the way to the Supreme Court. This is going to be law of the land. It's going to be
exactly what she thinks. She's changing the arena of law, of the justice system right now.
It's going to be Brown versus Board of Education, then Boone versus Boone Alimony case that everyone's going to learn on their first day in law school or their first semester.
Regular Aaron Brockovich, this one.
Yeah, they should actually use her case to, like, being like, I'm sure in law school you have additional classes you have to learn beyond just the law. Maybe it's like how to deal with clients, right, as a case, right? And Sarah Boone has got to be a top, like, what do you do with the Sarah Boone? Yeah, she is the Rosa Parks of the Florida legal system. She will not give up on her justified, constitutionally guaranteed alimony.
I mean, she should be suing the Torres family, quite frankly. I don't know what she's waiting for.
Typing play.
Respondent's motion for contempt. Florida law mandates compliance with court orders unless a modification has been officially granted. Petitioner has continuously failed to pay alimony as ordered by the court in the marital settlement agreement and final judgment without any such granted modifications. Is willful violation of deliberately refusing to comply and without any justification or...
Yeah, see, this is, again, where she's already, well, you put willful violation and deliberately refusing. So if it's willful, it is deliberate. You don't need to put both of the words in there. But I don't know.
Permission is contempt. Petitioner filed a motion to continue on respondent's motion to contempt, arguing that pending his modification petition constituted a change in circumstances under Rosenblum v. Rosenblum 2015.
Okay, so Rosenblum v. Rosenblum. I'll just pull this up again because she gets this wrong. Rosenblum v. Rosenblum. Where is it? I looked up all these cases.
That's impressive.
Oh, did she cite it as Rosen versus Rosen? 1 second.
No, I think it was Rosenblum.
No, I know it is Rosenblum, but I'm saying I grabbed the captions at the end.
Oh.
And I'm wondering did she type Rosen versus Rosen? Or did I do it because I was drunk?
We've already established this. You were not drunk.
I
think it was Rosenblum that was in this letter, if that's what you mean.
Yeah, Rosenblum sounds correct.
Yeah, I'm not sure because who knows? It could have been both.
So, well, let's just assume here 1 second. I've got Rosen v. Rosen in my search. They all the cases that I looked up that she's citing, they deal with either you can't be held in contempt if you weren't properly served, right? Or there is a right to, it has to do with, I mean, stuff that's just not even connected remotely to her case. Change in circumstances, again, they were all permanent to temporary. So like one of them was there was a alimony a judgment, but then it turns out the wife had a bunch of stocks, which she didn't disclose or something, or they provide cash in terms of maybe a dividend, etc. So then the alimony was reduced by that, or it was changed from permanent to needs-based. So, I mean, I'm sure there are cases where it says just because you can't pay doesn't automatically mean you get to have it modified, right? That's common sense, Sarah. That's why you have to have a hearing, because if it was just that simple, people would go online, update their income, right? Okay, and then it goes, okay, your owed alimony right now is reduced to X, right? People are just updating their information. That's why it requires hearings. It doesn't mean though that it's impenetrable or carving granite, right?
Yeah. I also think that anything here that refers to the actual case law was not done by her. It was done by that Peter guy, whoever typed this up.
And she keeps going here.
This case states that a party cannot be held in contempt if they lack the ability to pay, which petitioner did/does, but actively chooses not to as well.
Okay, yes, that's the point. So it can't be held in contempt if they lack the ability to pay. And her counter argument is, but he can. Like,
yes.
Yes, okay. That's something for the court to decide, right? So it doesn't make Rosenblum v. Rosenblum inapplicable. It only matters like who can prove, who can pay.
Ordered while being encouraged by his counsel to continue such contempt, assuming without any family support, resources, money, an attorney, or inclusion, respondent would surrender to her circumstances and the petitioner.
But you don't know Sarah. You
No.
don't know Sarah. She will not back down.
They do know Sarah.
She is going to fight. Well, no, they think they do, but they don't know she's going to fight forever.
Right.
She is never going to give up.
She's
Never.
proud of how little she has and what a degenerate she is.
Oh yeah, wouldn't she be? Like, it's impressive the amount of how completely she's been able to destroy her life.
Yeah, because to her it just means she's a victim. It doesn't mean she had nothing to do with all that isolated incident.
I feel like Janika brought up he refused to pay due to her being in jail.
Right.
Not that he can't pay, just isn't accepting at that point. I feel like he brought up both. It was a two-pronged argument, which is a smart one to make. He say, hey, look, she doesn't deserve the alimony anymore because or the state, she doesn't have any expenses, right? But in the event that there, for some reason it's found that my client can't pay as well because he's been unemployed. That's what I'm saying. A two-pronged argument. They aren't related, but they both address kind of the same thing, because that's what a good lawyer does. He makes cognitive, reasonable arguments saying, hey, she's in jail, she shouldn't deserve alimony. But in the event, because anything could happen, that you get a judge that says, no, she still deserves it because it was agreed upon before the crime or whatever, it would look bad to then bring up, I can't pay. You have to bring it up at the same time. So that's it's forever.
Forever. This is forever.
However, Rosenblum requires a showing of financial incapacity.
What? Why does it keep pausing?
Not merely a change in circumstances of the receiving party.
I don't know why it's frozen. Is it my... I feel like it's my browser here. I'm going to back it. I'll be right back.
Such as incarceration. A petitioner fails to present any clear or convincing evidence of financial hardship to prove otherwise in his pursuit to seek relief from his contempt and obligation of...
Something's going on here. I'll be right back in a second.
Okay. Luminessa, I gave HearMeowt. We took a look at the bingo, big hit. We're going to figure out what to do with it.
All right, I'm back. Yeah, I do. I'm very skilled at, or very, shouldn't know the time. I think it was 9 or something. Maybe around here. What is happening here?
In circumstances of the receiving party, such as incarceration. The petitioner fails to present any clear or convincing evidence of financial hardship to prove otherwise in his pursuit to seek relief from his contempt and obligation of alimony other than his
No, there's only one case, Luminessa. So there will be two cases, right? So what Sarah fails to realize is all the stuff she brings about the personal property is irrelevant, right? Because that would be handled in small claims court. It would not be held in this alimony case, which I think Tanika pointed out, or maybe it was you, Suma, or somebody pointed that out to me a while ago. But all of that is irrelevant. And she even mentions, oh, I thought about doing this separate action, which is, so why do you bring it up? But it is not two different cases. There are two different reasons that she doesn't deserve the alimony, or she can't get the alimony from Brian.
Verifiable statement of being, quote, unemployed. His argument is legally and factually deficient without proper proof showing confirmation of such status in their attempts to delay the petitioner's payments and progress in this matter. In addition to court orders and Florida law, respondent has made numerous legitimate attempts to contact the petitioner while located at OCCD to inquire about her court-ordered alimony payments and concern regarding her son, vehicle, storage unit, bill payments, where the petitioner would repeatedly verbally abuse and lie to the respondent about promised payments, then tell her to, quote, call back, or, quote, call tomorrow, end quote, don't worry, end quote, with the same answer and outcome each time she would cooperate with him for years.
Another useless paragraph, but in addition to court orders and Florida law, it really bothers me as well when she puts court-ordered alimony, like the judge would forget. Idiot!
All of her eyes and crossing all of her teeth. Idiot.
Yeah, well, there's the court-ordered alimony, and then there's the non-court-ordered alimony. We know that she doesn't need to write it out loud because she has no problem using abbreviations for OCCD, right? She never writes it out.
That's because she doesn't know what it stands for.
And she doesn't really want to call out the fact that she was in the correctional facility.
Right. There's no need to bring that to everyone's attention.
I mean, that is totally irrelevant to what we're talking about.
Spell it out.
Both parties were fully aware the final judgment was in effect, especially and foremost after the judge verbally reiterated in court. Verbally reiterated? So, in other words, it doesn't matter because it wasn't an order. He's not ordering them. She says ordering both. She's so stupid. It gets on my nerves so much. Ordering both the petitioner and his counsel to continue payments in the case management conference on September 19th, 2022. Yeah, we don't know that they've happened, but we know that the judge didn't order it because there is no order. The judge just saying something is not ordering. A judge cannot legally give advice in terms of the law, right? There's maybe just commentary to lawyers based on, hey, you know, if we come back again on the same matter in a month, just letting you know, your circumstances will not be the same. Like usually when you see that in protection orders on trial, right? They're like, oh, I'm not going to issue one right now, but if you keep doing this and you come back, it probably will be a different outcome. It's like a warning, right? It's not an order. So the petitioner still refused to be inconsistent in any amount of payment, and the respondent being indigent with a growing negative account balance followed her motion for contempt to make the judge aware of his violations and willful disregard for the agreements and court orders. The respondent's needs of essentials were not being met by the facility, and her outside responsibilities were in jeopardy, which could and should have been fulfilled and saved would the petitioner have been making payments as ordered. The petitioner and his counsel... Wait, did she just talk about her 30-year bank account there?
Yeah.
Yeah.
And her Kia, which I looked up, and I'm a little disappointed that it's actually worth more than nothing.
Well, I said, right, $4,500 is what I saw for Kelly Blue Book.
I saw 6,000 something.
Oh, PSA, by the way, there are a lot of scams on Facebook for cars that are going out there right now. Not that I got scammed, but we noticed it was my sister-in-law's her brother's wife was listing a car online, and I've been looking for a car because I don't have a car, right? And if I have to drive into the office, and I want something cheap, right? But they basically hacked her account, but it isn't obvious, so they list the car with this whole backstory, and then they will say, you know, okay, well, the first person backed out. If you want to, then I was confused. I was like, well, how would they get the money from me? Because I'm not going to agree to pay until I'm there, right? And I'm guessing they probably say something like, well, I need half up front to hold it, or etc.
Something that sounds like a great deal. Or
yes, I mean, it wasn't an amazing deal. It was like a Honda Accord 2014 with like 140,000 miles on it for like 3,500. So I mean, 140,000. That's the time you got to do time belt, water pump, all that kind of stuff with Honda's. Side conversation. Don't ever wire somebody, or don't ever send somebody money for something online. If you're going there to buy a car, bring the cash, right? Or pay when you get there and you get the car and you get the title. Don't pay that. Don't pay any amount to hold it. It's a scam. Just try to save people out there. So yeah, it was funny because then we texted her and we're just like, hey, do you still have the car? And she's like, what car? Like, oh, my account is hacked. Like, oh, okay. Never mind.
Facility and her outside responsibilities were in jeopardy, which could and should have been fulfilled and saved would the petitioner have been making payments as ordered. The petitioner and his counsel unilaterally made the decision to stop her entitled payments.
$4 a month. That sounds like what I pay for my son.
Completely avoiding the court, due process, and her active legal right to alimony. Their actions are not only unjust, but undermine the capacity and authority of the court.
That's her other common line through all this shit. She keeps saying how much they're insulting the court, right?
Yeah, of course, because the court's going to believe that too. Like,
wait a minute, are they making?
They're insulting the court.
They're insulting the court. Oh my God, Sarah, I can't believe you. Thank you for showing me how much I'm being disrespectful. You know what? I am the court.
I'm not going to put up with this, and neither are you. Court.
I am not going to put up with this at all anymore, Brian. You are going to pay. I've had the wrong layout in there. It's too blunt. There we go.
It's legal protections that are to reinforce and ensure rules, fairness, support. Case law. Florida Statute 61.14. Blah 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 blah.
And you don't put them at the end here, Sarah. You put it right after the argument that you made, where you say something like, Florida's law says that incarceration doesn't affect alimony. Then you would put Bowen v. Bowen, the reference, in the paragraph. You don't list it at the end like an idiot with 8 references, because the judge isn't going to look all this stuff up and say, okay, well, what part is in which case? They're not going to read the entire case and go, oh, okay, that's what she was talking about here. And that's what she's talking about here. Now, we know that she did it below because she can't actually line up to what she's saying because she's just spouting a bunch of bullshit. But don't even bother putting it in there. I like at the end when she says, when the judge says you have to provide the case law or examples of the cases, she goes, well, just see above where I listed it. And the judge's gonna go, okay, I'll look it up on my own.
Yeah. Oh no, I've got time. I'll do the work on this.
Yeah, she didn't make an argument. She made an argument, but it was a bad argument. It's, there's Rosen and Rosenblum. Okay. I looked up Rosen.
Thank you, Buffy.
Blah 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 blah.
I like how she puts all this case law down here, but doesn't ever quote it above. It's like I was reading my own brain, like what it is. Probably because she's a moron.
Resolutions.
Another resolution section. Gee, I thought that's all the
Resolutions. Respondent respectfully requests the court to 1. Rate her motion for contempt for lawful reasons stated in this pretrial memorandum, denying the petitioner's motion for continuance and termination of alimony, as his argument lacks legal merit and does not justify non-compliance with active court-ordered agreements and inactive modifications. This has caused the respondent unnecessary financial hardship and loss for over five years because ongoing unlawful withholding of her entitled alimony payments to prosper in her current circumstances.
Only Sarah would talk about prospering in jail, right? Just come on, Sarah.
She's going to prosper wherever she is because she's one of the Lord's disciples, one of the,
Yeah, she's a martyr, right? She's been sacrificed for.
She's a survivor.
Mm-hmm.
And she's a spokesperson for the oppressed.
And Sarah, what makes your motion something that still needs to be granted? Now, you didn't reapply for it, so you're screwed anyway. But why is your motion valid as something that hasn't happened yet, but we need to be granted? But their motion is total bullshit. And
It's family law matter in her life as a whole.
Yeah, that's right. Brian didn't ask for a continuance. She said she didn't want to have the trial because she didn't want her current circumstances of being in jail to be considered. Now, which is funny because now you're in prison and you somehow think it's not going to apply. I mean, if what you're saying is true, Sarah, you could have just made all these same arguments back then. My current status doesn't matter. Shouldn't be affected. It shouldn't unnecessarily sway the court.
2. Enforce the alimony order in the final judgment and underlying marital settlement agreement. 3. Compel petitioner to produce evidence of permission from the court to reduce or terminate any alimony payments to the respondent. 4. Impose appropriate sanctions against the petitioner and his counsel for filing a baseless motion to continue, unnecessarily delaying proceedings in the respondent's lawfully owed ordered payments to.
What motion to continue is she talking about?
Is she talking about the one that she wanted?
No, she's saying that they filed it.
Oh, I don't know. She might be talking about when, I don't know.
Let's see here. Motion to continue. Motion. Okay, that's her. Motion. It's her again. Motion to compel. Does anyone know what motion she is talking about in terms of continuance? All I see is her bullshit. Which you see a bunch of orders. Oh, here we go. Motion for continuance. What is this? Comes out Brian C. Boone. This is okay. On April 11th, the respondent filed a motion for contempt alleging the petitioners. Wait, I can share this. Sorry, rather than me just read it, but I share it, huh? I think I remember this now. Yeah, this is the whole reason. We're sharing. There's a motion, window, Chrome document, sure. I don't know if you guys could see this enough, but so she wanted the contempt hearing, right? He basically filed a motion continued saying, no, let's figure out their motion to modify, right? The petitioner has filed a petition to modify alimony on April 12, 2022. That is still pending, right? What is she talking about? So she's saying because their motion is bullshit, they shouldn't have been able to continue it, essentially, right? That's what she's saying.
Rightfully thrive in her life.
Bloodbath wants us to do the Brady Bunch thing. So you have to look down.
Oh.
And then I'm supposed to lisp.
Impose appropriate sanctions against petitioner and his counsel for filing a baseless motion. It's not baseless. It's entirely based. It's saying the reason she is filing a contempt is for the actions that we are taking based on our motion to modify. Oh my God. She's insufferable.
Idiot.
An idiot. Thrive in her life, needs, and responsibilities, regardless of her status and location. No, it's not regardless. The entire point is your status and location. That's why it needs to be modified.
Convicted felon for the worst felony you can possibly.
Convicted murder felon.
Murderer.
Needs and responsibilities, regardless of her status and location. 5. Impose further sanctions to petitioner for failing to obtain legal modification granting formal permission before reducing/ceasing ordered payments to the respondent.
No, Sarah, that's not how it works. You decide if they were incorrect in doing it first. Then you apply sanctions. You're just jumping to the conclusion that, okay, well, I proved above there should be no modification. Therefore, let's talk, what is it called? Talk turkey. What's the phrase? Let's talk turkey here of what we're going to do to straighten Brian out and get his attorney disbarred.
Right. Yeah. She wants everyone to go down for this.
Everyone.
Bullshit alimony that shouldn't even be an issue. And child support.
Well, she does acquiesce to the child support as long as she gets to say what it's spent on.
And every single thing that the child, every moment of that child's life.
Right, every moment.
And we're not talking about a small child here either.
What would be best for Sarah is if we just put a GoPro on head so that Sarah could have a direct feed or can review everything that is done and then know anytime that anything is said about her, which I'm sure people just yell at him all the time.
I'm sure that Brian...
It would be kind of funny if he goes, yeah, I'll wear the GoPro. And then for like a whole afternoon, everyone's going, your mom's such an idiot. She's so stupid. Oh, we all hate your mom. And then she gets to review and she's like, who are those children's names? Tell me those boys' names.
Yeah.
Oh.
I'm sure if Brian offered her money to never see her son again, she'd be fine with that. I mean, he's not going to.
Yeah. How much do you think she had to resist to put that in there? Look, I'm willing to accept the payout and then
leave them alone.
And then not have any
I don't
involved.
think she's smart enough to even think of that. Otherwise, she would have put it in there.
Oh, yeah. Okay.
5. B. Personal property. Please also refer to respondent's filed financial affidavit.
Hopefully you're not really leaving.
List of all personal properties to be divided. 1. 2011 Kia Sorento. 2. Personal.
And again, not to pretend to know the law better than Sarah, but wasn't this section called personal property to be divided? So she wants the Kia Sorento in the personal storage unit to be divided amongst them.
Also, when she gives that list, that first where she's like that he, arranged all of the storage for her.
Yeah, voluntarily.
Right. He did all of these things. That's the first part of it. And I'm like, that's all I would have to read. I mean, that's a huge pain in the ass because you had to go kill someone. No, anyone else would have sold it all of it.
He agreed to legal binding obligation in perpetuity. I could be in here for 20 years and he would have to produce my 2011 Kia Sorento in the same exact condition it was in when I went in.
And how about if you never come out? He's gonna
then I better see it in the parking lot outside in the exact condition it should be in. Tanika was saying on SKR stream that she believes that Brian would have taken his pictures out of the storage unit if they were even in there, right? Because she talks about baby books, and I'm pretty sure. I mean, if you were Brian, why wouldn't you contact her brother, right? If you're paying for this thing, right, you don't want to pay for it anymore. I think the first thing I would do is contact. If
he may have his brother said, "You're on your own. Do whatever you want. I support you," and we never had this conversation,
right? Or God forbid, my wife ended up in jail forever, or she's my wife, so I don't have an ex-wife, but whatever. She ends up in jail forever.
Right.
And
Forever.
she has a brother, right? And I knew there was stuff in there. The first thing I would do is say, hey, I can afford this locker, but her stuff's in there. Is there anything you want to come get out of it? Or do you want to pay for it and keep all this stuff? Right. That would be the first call I would make. I would not ignore and be like, I don't want to talk to her brother at all about this. I'd rather keep this on myself.
Right. But we also have to keep in mind that with Sarah, she may say this now, but the truth is, I would guess that she does not want. She would do anything and probably did to avoid Brian talking to her brother, because Sarah does not like when people talk behind her back, so to speak, or like compare notes kind of thing. So she was probably like, I asked my brother and he couldn't do it, but now she's all in and you can ask my brother, I told him. Just a hunch.
Yeah, share in touch. That's what I'm saying. Like, I mean, I don't. Brian does not seem, to me at least, to be somebody that gets joy out of vindictive.
The only thing that was in that
imposing stuff, because at that point you're not hurting her because she's going to be locked away forever, right? But maybe there's something for your son, or maybe her brother who's innocent in this thing. Maybe there is some kind of maybe there's a, what do they call it, an urn or something? Maybe somebody's ashes are in there, right?
Probably all of his things are in that storage because that's all she had, really. But Brian's problem is that he's not nasty enough. He's too.
Right, he's not nasty at all. That's a call he's going to make. He's going to say, "Hey, she's got a bunch of shit in there. It's going to get auctioned off because I can't afford it." Right. But do you want anything? Do you want to go look and see if there's anything in there that you want before it's auctioned off? I can't imagine a universe where Brian does not make that call.
No, absolutely.
Or where Brian and her brother are not on good terms somehow.
No, definitely. When you know someone like Sarah, you have to get into a force with everyone else. You have to join forces with everyone around them, because if nothing else, just to find out that you're not the crazy one.
Right, exactly. Boone and her brother were estranged. Yeah, no, I get that. I'm just saying, I don't care if somebody is estranged from my ex or whatever, right? I still think unless it was just obvious that there was no heirlooms.
He wasn't talking to him before that, but once this happened, they may have touched base. No.
Yes, and it would be the number one goal to get. I don't want to deal with this. Do you want a car? Right. That's the other thing that's making sense.
To drop off the fish soap or something, bring it to Brian. She had some plan there. She's very busy. I mean, these people are busy, they're not, and even if they're not, but she's giving her brother all kinds of jobs to do.
I think they don't have each other's contact info. That'd be weird.
Yeah,
it'd be weird to not have his contact info just in case there was an emergency, or let's say Sarah died or something before she was arrested, right? You're never gonna be able to contact them. It doesn't, whatever. But yeah, she acts like these are all things that were no obligations to Brian, and he did it on purpose. He wanted to get rid of it. He was going down to the office of the storage unit, hey, can you auction my unit even though it's currently up to date, right? Can you auction it? Go ahead, please. I'll pay you extra to auction it.
I just don't want it anymore.
Hello, baby. Hey, did you check out that stream I sent you? Hello, baby. Maybe not. Maybe.
Storage unit. B. State the suggested disposition of such property. Immediately upon respondent's incarceration, petitioner took possession of her vehicle directly from the sheriff's office and secured at the marital home.
So we did you a favor. Okay, there's favor one.
After verifying the placement and safety, he verbally promised the respondent to manage, and both parties mutually agreed upon him taking full responsibility of her property while her case was in progress.
Bullshit. Why would he ever do that? Right? Susan Boone. Well, I don't know if you...
Susan Boone. Thank you.
Suma was talking about this being a super chat video. Well, we'll just...
That was my idea. If you're not into it, I
apologize. Now, I didn't necessarily
think
that...
often out of the country. Yes. Yeah, that was not his choice.
Susan Boone, $20. Brother was often out of the country, maybe. Yes. And brother mentioned that he and she had not been in contact much in one of the messages. Yes. Yes, you're absolutely correct, Susan Booney. Because he is in the military, right? So he's probably on tours of duty, right?
The brother gets her more than anyone.
But even in that case, his brother's wife is still in town, right? Because she says later in the things, hey, he could have given it to my brother, but he refused to do that, right? So there has to be some evidence of a conversation or she lied about it, right? But I don't see, there's going to be, even if he's out of town, you call the wife and you contact him, email him or whatever, even if they don't have the phone number, you email him, say, hey, the storage locker, I know you're out of the country. Does your wife want to come and take a look at any of this stuff? You could talk to her on the phone or something while you're there. And the comment was, Philip said that my wife knows my side of the family has not been in contact with me, right? Because basically he's cut off. Well, why wouldn't you, right? Your pedophile brother and your murderer sister. Geez, that's rough. I
mean, we saw a few texts, like literally 2 texts between them. The text that they showed that they didn't read it, but in court, she was obviously telling him that something had happened with George, and then she didn't get back to him for, he was like a shitbag on. I think that's what he said. He was like, had only heard her side of the story and was probably trying to be supportive. She didn't answer him for a long time, and then finally he was like, "Are you alive?" He's probably like, "I should probably follow up on this," but.
But thank you for the donation, the super chat, Susan Booney. It's very helpful. Because as of tomorrow, you were talking to an unpaid. Did you listen to that stream from Reborn that I sent, the one about the Italian job?
Not yet. I have to, though. I want to.
He starts with his big surprise to Jamie's. He says, "You are talking to an employed person." That's his big reveal. No, he's not, because it's the mayor of Italy looking for property in Cornville, Maine, and he only has to work 8 to 12 hours a week, and he gets paid $4,000, which is. And he didn't even apply for the job. He doesn't remember applying for it, but it's not a scam. If Brian were to auction out, he couldn't take my money fast enough. Oh, you would buy them, pretend judge?
You know what? I wish I had known when that auction was, because I'll tell you what.
I would buy them to burn them. Well, no.
Oh, no, I would go through all her shit. I mean, that's the kind of thing I would really like doing.
I wouldn't burn the heirlooms necessarily. I'd probably
there
burn
are no heirlooms.
Well, okay. Well, maybe it's like a little picture
or
something. We're expanding the definition of heirlooms, right? Heirloom, it could just be one of those old black and white photos.
Unless we're expanding it to things you buy with Camel Cash, there are no heirlooms.
Well, they're standing there with the bottle of whiskey and the shotgun next to it in the old timey.
Oh, in the picture you go to the studio.
Yes.
That's right.
Like
that's
maybe
possible.
One of those. Speaking of the banjo music, I was trying to think. Keep talking a second while say something funny.
Me?
Yeah.
Something funny.
Yeah. Oh my God. Let me change this. Okay, talk amongst yourselves for 1 second, children.
Okay. About myself. Well, I wasn't breastfed for very long. I've heard.
Till age 9. That's totally normal.
Mother told me that my first cat got married and moved in with her husband. And I believed it until I said it out loud in my 20s.
All right, can you hear banjo music now?
We can hear it the whole time.
You can hear it the whole time?
Well, I mean, I heard it when you first started it.
You shouldn't be.
It's loud now. I mean, it's...
Okay. So this is what I imagine Sarah Boone. Is it too loud when she's talking about?
Yes, a little bit maybe.
Okay, when she's talking about her
I wouldn't
family.
collect Sarah's items, but I would go through it and tell you all about it for sure. I'd be like, check this out.
I'd burn the couch, whatever I could.
I mean, I wouldn't go through. I think it would just be very funny to see how few things were really in there. And I think that George is back to his family.
I play banjo. Is that an issue? No, there's nothing wrong with banjo. I'm saying this is the more Sarah describes her family, it's like some kind of bootleggers out in the woods of West Virginia or something like that.
Yeah, they're on their porch smoking a joint and tap dancing.
You're 2 hours behind, Ben Aaron. You'll see this when you get to this. You mentioned slavery, right? It made an exception for prisoners, but I think there still has to be compensation, which is why they do the 25 cents. Otherwise, why do it? Right? Yeah. No, I don't imagine it's a bluegrass band. I'm just taking Sarah's description to the extreme.
Petitioner also proposed in court.
What?
Did you see the wonderful whites of West Virginia?
No, I haven't seen that.
Okay.
Yeah, just be out back, Whitlands.
Needed a storage unit where her belongings from her townhome were placed and secured. She repeatedly inquired about her personal property from the petitioner to ensure protection during, including setting up other arrangements at no cost in case the petitioner refused and discontinued to cooperate in paying his obligated alimony to cover. Petitioner would continuously tell respondent to, quote, not worry, end quote, quote, I've got it covered, end quote, quote, nothing is going to happen to them, end quote, quote, it will be taken care of, end quote.
It's weird he says all these things when he never responds. Isn't that odd? Like how
he forces her to because he doesn't respond. So what you gonna do?
Yeah, it's just weird.
Like, that's what I was saying yesterday. How if she says that they never have talk about these things, how does she know all this? And if he's not responding to just her text, which we know that's the case because they've had conversations, who cares? Stop texting him.
When she would ask for a status update to make sure he was really doing as promised to save her last ultimate resources and generational legacy to share with their son.
She couldn't resist. She had to say ultimate resources. But, here's the thing. When I trust that somebody's doing something or somebody says something, right? Why would I keep following up with the question?
Because you don't get the answer you want, or you don't get it fast enough, or it hasn't come to fruition yet. And, because you're Sarah, you ask it until it's done, and then you start asking for something else.
Right. But if you're saying, hey, you're taking care of my car, right? And they go, yes. You go, okay, cool. All right. That's the answer. That's the only answer you need. You don't need to keep asking the same question, because what if they say, no, I'm not taking care of it? You have to deal with it.
Same thing.
Then it was a warning, huh, Sarah? So,
yeah.
Respondent felt the petitioner was being untruthful after not receiving any updates other than the aforementioned 4 years and coordinated turnover of her vehicle's keys, lock and keys for storage, with information to be given to her brother, who lives locally, for safekeeping and to provide relief for petitioner.
See, that's... Oh, go ahead.
I forgot what I was going to say. Sorry. Go on.
I'm going to say that's a really bad statement, because Philip is listed as a witness by her, right? I don't know if Philip will be there. I doubt it. Maybe he will be virtually. I would think I would want to call him if I was Brian, right? And say, hey, did I ever contact you about the car and the storage thing? He goes, yeah. And did you want them? He said, no, I didn't want them.
Yeah.
That nukes her whole case. So it's really bold of her, unless she knows absolutely that
She's
he is not
thinking
going
about it. She was on the stand showing a picture of her with a stab wound that she showed the other side of the other leg. She's not thinking about what the evidence or receipts show.
Maybe it was just reversed image. Okay.
Maybe, but then it was still on the other side of her leg.
Okay, but she can't be held responsible for trick photography.
Everything being spliced and whatever she said.
Look, you tell me and we'll both know. Margarita is right.
Yeah. But I mean, she's absolutely not thinking about any of this. She's saying what she wants people to believe because she's an idiot and because it works for her sometimes. So because nobody wants to go look into every single thing she claims.
I bet she never contacted Philip until she got arrested.
Definitely. Absolutely. That's what I mean. The last text from them was, a year before or whatever.
Can you imagine that phone call? Hi, look, I got arrested.
I miss Mom, don't you?
How are you?
Remember
by the way,
when Mom died last time we saw each other?
I'm good other than I'm in jail. So I was wondering, can you go ahead and send me some bail money? Yeah.
I'm sure he wasn't very surprised.
No, of course not.
Peace of mind for the respondent. After concerned repeated efforts and no-cost solutions by the respondent to acquire her personal property, keys, etc., petitioner finally stated, quote, "The keys were lost in the mail," end quote. Since this last statement by petitioner, respondent has utilized her outside resources to locate information for this case and possibly filing an unlawful disposal suit against him, found out her vehicle was scrapped, junk/salvage, and storage unit auctioned off due to abandonment. Respondent made every effort to save her personal property, provide answers, multiple solutions and arrangements to the petitioner for these to be successfully taken care of and protected during her incarceration, after petitioner promised and continuously assured her would be. Petitioner had a legal duty to return or inform respondent before disposing of or abandoning her property, and should lawfully be liable for total loss and damages of C. List the value of each item of personal property. 1. 2011 Kia Sorento, 75,000 miles. Website 1, certificate of destruction. Website 2, A400. Website 3, 2, storage unit, based on estimated value of irreplaceable contents, including antique jewelry, furniture, unit as a whole, $10,000.
That's pretty low, actually, for
It is pretty low,
irreplaceable contents.
But also, you can't put a price on things like that because something is worth what people are willing to pay for it, and there's no saying, I mean, Sarah was not an aristocrat, as we've already established. She didn't have a Louis XIV desk in there. A stained lazy boy and a broken TV. Like, I don't understand what exactly. And a broken banjo.
Yeah. So, the only reason I say that is because I don't know if you've ever had a apartment flood or anything like that, right?
I haven't. But...
So we had our apartment flood in 2016. It was the neighbor or the person upstairs, right? Their hot water heater leaked, and basically they were away for the weekend, right? So it filled up the apartment like a couple inches, and then it found an exit point in our apartment below, and it basically broke through the ceiling and flooded our apartment instantly. It was very weird because I was at home. It was a Saturday afternoon or Saturday evening, like 4 or 5 o'clock, right? I'd go out, and at that time we had the TV in the bedroom and went out there, right? But I was inside. The boys were at their dad's, and my wife was still at work. So I'm in there playing Xbox, and I go to the kitchen, grab a beer, go to the bedroom, go out maybe 5 minutes later because I forgot something. And as I step out, I step into a puddle that is several inches deep. And I'm like, what? Yeah. Like, it doesn't make, the entire apartment is flooded. There's been no sound that I can hear. And I'm like, what is happening?
Those things are, when there's some things like that happen, it's always so surreal. It's like crazy. You have to like readjust. Like, what is happening?
So then I go further out. It's coming through all the light fixtures. It's coming through the laundry. It destroyed the apartment, right? They had to basically cut up all the walls up, like the apartment complex had to do that. It was renting. It was just renting. Yeah. But we had renter's insurance, and I was like, it was like $40,000 or something we had. And I was like, it's gonna be plenty. You know, when I talked to the people that were coming, I think it was like ServPro or something. I was like, we got a policy, it's like $40,000, I'm thinking should be no problem because not a whole lot of stuff I figured was damaged. Maybe it was the stuff that was like a comforter, right? That was in the whatever was in the laundry room was toast because that's where the water was coming in. But the electronics and all stuff were fine. The couches, right? Okay, well, replace those. And they're like, oh, that might be tight because of the expense of them. They basically are moving everything, cleaning it, and then bringing it back. But it came close to the 40,000, and I think even just the food items, right, and was a couple hundred itself. And you think about stuff that doesn't perish, right? Well, you have like little packets like Kool-Aid and stuff. So I mean, I went through because I wanted every penny,
of course,
back, right? So I was Googling everything that they had, but it's amazing how much that stuff adds up. So 10,000 for the entire storage locker of your life is very light, and it means you don't own shit.
Right. Well, I think to her that was a high price, but also, I mean, and I could be wrong, but I think that's a very different situation. For example, if she has non-perishable spices, for example,
okay,
in her what she's talking about is high ticket items that could have been sold at auction or whatever, like that she could have things that collectibles, heirlooms,
Well, I mean, even when we
Beanie Babies.
No, it did not find. So what ended up? Okay, just to wrap that story up. So what happened is they moved us out of that apartment, and the one that was above us, the one that flooded, they were moved out as well, and they were moved into one of the apartments that was open. And I was like, well, that first apartment's like, oh, we can have this cleaned up by Monday. Like, are you kidding me? Are you seriously kidding me? The water has come from above and below, and it all flooded everywhere in this apartment. I was like, there's no way you're going to have it cleaned up. And we were fortunately, we were a unit on the second floor that didn't have one below on the first floor, but it flooded the offices that were below onto the side. It just was a disaster. But they moved us up to the one that had flooded because all they had to do was replace the floors there. And I was like, yeah, move us up to that one. It took a couple weeks for them to finish it, but they didn't finish fixing our apartment. They gutted it because they had to, right? They took out the mirrors. They took everything out. It was down to the studs. It took them 2 months to fix that.
It's easier than to have to get it as dry as they would have to prevent mold, I would imagine.
Yeah, and they were trying the dryers at first, and it just was not going to do it because there was so much water in that apartment. Yeah, I mean, just imagine like it was like 900 to or 1,200 square feet, I think, actually. Just that much times 3 inches of water. It was a lot. And then it actually resulted in a very awkward encounter because I still had the key for the apartment, and I kept going in there to like look at what they were doing just out of curiosity, like, oh, what, they've updated this and that. They replaced. Oh, it looks like they got new hardwood floors, all right. And I did it one more time, but somebody had just moved in.
It happened to me in my last apartment. Someone came into my apartment. I was like, hello. She's
like, excuse me. And I'm like, and I had a key, and I was like,
yeah. So did
I was like, oh my God, I'm so sorry. I didn't know anyone moved into here. I used to live in this apartment before they remodeled it. And I just have been checking on how they were doing it. I'm your neighbor. I'm upstairs. By the way, here's a key to your apartment. This is the last one we have. Don't worry. I'm not going to be coming in.
Changing the locks anyway. Crazy.
Yeah. Apparently they didn't change the locks for you. But it was fine. Whatever. Anyway, enough of a tangent there.
Case law, Florida statute 772.11, 715.
That's not case law. That's statute. Fucking moron.
And 83. Resolution. Respondent is requesting status and or return of her personal property listed above from the petitioner immediately. Page 6. Item G. Attorney's fees and costs. Respondent continues to attempt to understand her position of defense against the petitioner in his request to charge her with his attorney's fees.
What do you not understand? He wants to charge you the attorney's fees.
As in the supplemental petition, it states due to not signing their joint stipulation and in their pretrial memorandum, quote, resulting from the chaos created by the respondent's criminal conduct.
That's it. That's where she hates.
That's the. I read that when I read it. I was like, oh, there we have it, and there we have her. Straw.
She's trying to frame it as like they told me I had to sign or else not, and then it's all their fault because I have my own rights. No, it's because you wouldn't agree to any mediation. You wouldn't agree to the trial because you wanted
cancer, I think, at that time. So
she also had cancer. Yes, and she was exploring outside medical options. She didn't know where she was going to be.
Yeah,
and she had all
we
these
knew
questions.
where she was going to be, but she had no idea.
She had no idea. She wanted to make sure, well, who's the mediator? Where's he going to be? What's the relationship with your law firm? All this kind of stuff. And then she would be able to consider her dates that would be available. So it's very cut and dry, Sarah. You prolonged this because you refused to do any kind of mediation. You refused to proceed with the trial because you didn't want them to consider you being in jail as part of the evidence because you thought you were going to beat your case. And therefore, that caused Brian to have to continue hiring the services of this lawyer for the past 2 additional years, plus the cost it's going to take to respond to your 33 pages of bullshit.
Yeah.
Okay. I that's the other thing I don't understand about pro se defendants. They when there is attorney's fees in there, you should realize like, hey, the more work I make them do, the more likely it would be that I'd be forced to pay attorney's fees.
End quote.
But
1. The petitioner and his counsel did not ever, quote, attempt to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental motion for modification, end quote. As stated, nor, quote, the former wife would not sign the joint stipulation, which resulted in the filing of this action, end quote. The supplemental petition to modify was
yeah. I remember the same thing, Buffy. I don't remember what it was, but I definitely remember something along those lines. Like, hey, you got to send someone over here to get your crap. Which is weird because Sarah says she had already given her brother's contact information. So Brian, rather than contacting the one person that Sarah said would come and deal with it, said, hey, you got to contact somebody to come get your crap.
Received via summons the respondent with no other correspondence or notice of any kind provided prior as suggested to avoid any presumed costs incurred.
They're really old. Oh shit. I click back too far.
Petitioner, to clarify the untruth for the court to fully understand their self-inflicted
hey,
cause
chat, were we ahead of this or behind this?
The timeline is as follows. A. February 18th.
I don't think we were that far.
Of filing a contested supplemental motion for modification, end quote. As stated, nor above from the petitioner immediately. Page 6, item G, attorney's fees and costs. Respondent continues to attempt to understand her position of defense against the petitioner in his request to charge her with his attorney's fees.
Right, Kathleen.
As in the supplemental petition, it states due to...
Yeah, if all she had to do to not destroy her life was unzip that suitcase. But if she had done that, she wouldn't have been able to renegotiate his terms of surrender and compliance. So...
not signing their joint stipulation and in their pretrial memorandum, quote, resulting from the chaos created by the respondent's criminal conduct, end quote. 1. The petitioner and his counsel did not ever, quote, attempt to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental motion for modification, end quote. As stated, nor, quote, the former wife would not sign the joint stipulation, which resulted in the filing of this action, end quote. The supplemental petition to modify was received via summons to the respondent with no other correspondence or notice of any kind provided prior as suggested to avoid any presumed costs incurred from this filing by the petitioner.
What are you talking about, Sarah? The supplemental petition to modify... Well, first off, you don't need to send any additional documents with them. When you send an order or a copy of a petition or some kind of modification order, it's self-inclusive. There's no additional extra information that should be needed to understand it. Otherwise, it'd be pointless as part of the court record. So that's stupid. just want to check something here, though, because if I remember correctly, what was it? It's called supplemental petition to modify, right? Was that was filed. Supplemental petition for modification. Well, I only see the petition for modification. Oh, okay. It's called supplemental petition. Yeah, that's exactly what you do, though, in a legal process. Were you saying you were voluntarily giving up the alimony, Sarah?
To clarify the untruth for the court to fully understand their self-inflicted cause and confusion, the timeline is as follows. A. February 18th, 2022. Supplemental petition for modification of final judgment. Generated.
Oh, she just listed it out there. Again, you don't need any of this shit in here, but
by petitioner's counsel before.
I know. His lawyer didn't do it.
For Joshua Martell. Signed by the petitioner, Brian C. Boone. E. April 12th, 2022. Summons sent by Martell to process server for scheduled delivery to respondent. Included documents. A. Notice of appearance as counsel, Joshua Martell. B. Supplemental petition for modification. Served 2 months after originally signed by petitioner. C. Joint stipulation for modification. D. Uniform child custody jurisdictional affidavit. C. April 21, 2022. Summons received by process server to be delivered to respondent. D. April 22, 2022. Summons and inclusions for delivered to respondent at OCCD. E. May 1st, 2022. Respondent's answer to summons sent to petitioner as instructed. F. May 16th, 2022. Respondent's answer filed with the court by petitioner.
And we know what her response was, right? If we remember it correctly, the long list of bullshit. Let's see, what was it? May 16th? Pull this up here. I know I read it. Answer. It was 9 pages of bullshit. I'm writing in regard to a summons I received stating a lawsuit has been filed against me in the aforementioned matter. Who did she even write this to? She said, dear sir or madam, and sent it to the marriage division. Yeah, 9 pages of single-spaced bullshit.
At the end of this, she really kisses the court's ass.
Yeah, I'll just read it for those who don't remember. Thank you for your time in reviewing my formal written response in regard to, in part, to the petition. I am grateful for your understanding and hearing my side, also, which is only fair and right to do. This is between both parents. I wait your response and instruction. Please do not hesitate to let me know if anything further in my ongoing unreserved cooperation is needed. I'm still in this, still a person whom former husband was married to for 13 years and has known for more than 20. Most of all, I am still the mother of our son and still important in anything/everything pertaining to him, come what may. Sincerely, Sarah K. Boone.
I think May already came. We know what come what may now.
G. July 5th, 2022. Petitioner's correspondence attempt with respondent, quote, to schedule a mediation for our petition to modify as is required under Florida law, end quote. H. July 17th, 2022. Respondent's answer and transparency to correspondence in confirming her want of participation with...
That's the one where she listed all the bullshit. The one from July 17th. Yeah. Whatever.
She saw white.
Concerns. I. July 26, 2022. 1. Motion to dispense mediation. Filed by petitioner claiming, quote, the respondent is refusing to coordinate a mediation at this time, end quote. No hearing held for this motion.
Because they asked you for a date and you wrote back a list of 10 things you wanted.
not included or able to defend herself against another, quote, refusal accusation made by the petitioner and his counsel. The petitioner is accusing the respondent of, quote, refusing to sign their joint stipulation, which was served on her over two months after it was signed by the petitioner with a previous attorney and nothing.
Yeah, it doesn't matter at all.
I mean, she's not even making a point there.
No, she's making a point that there's something nefarious going on.
He thinks she's making a point, but she's not.
She's like, did you know he had a different attorney when he signed it?
He's like, he signed it 2 months before. So what?
But it was with a different attorney.
Yeah.
Okay. Should we go ahead and bring him up on bar charges right now?
You want to talk about how many different attorneys you had, bitch?
Well, that's neither here nor there.
Not by choice.
Thing attempted to do with before. His counsel made false statements in their supplemental position, page 3, 7, and to the court for the reason the document was generated, which was before Martel even became the petitioner's counsel and before the correspondent.
You know what you do, Sarah, when you say statements like this, you list what the false statements are. You just can't blanket saying false statements.
The physical copy of to read, review, etc. The joint stipulation was sent the same day in the same summons with the supplemental petition to modify and petitioner's notice of appearance of counsel introducing Martel.
So
no
what?
joint stipulation was ever sent to the respondent before the petitioner filed their supplemental petition to modify, giving no opportunity for her to, quote, refuse signing, quote, which resulted in the filing of this action.
Did you sign it, Sarah? Because if you didn't, it's a refusal. Yeah. You have not signed it.
And she just said that, didn't she? I mean,
well, the best argument to counter saying, no, I didn't refuse to sign it, was I did sign it.
End quote, as libelously claimed. Because of their untruthful statement also, an improper handling of these documents, a joint stipulation foremost, not being received by the respondent prior to their supplemental petition to modify, a right to mediation was forfeited, which has been avidly and emphatically sought by her since the beginning of this case.
No, you give a date if you want to have mediation. You don't write a letter back with 10 bullet points, starting with, what are the requirements under the law? Can you tell me? Please provide all copies, send contact information. Will the former husband be in attendance? Who is the judge? Is there going to be an agenda? What if the selected date needs to change? Is the point of the mediation to force me into signing and agreeing to the only terms available? What if I do not agree? Is this a video scheduled conference? Will this be a private meeting? Is face-to-face an option? That's all the stuff you said. You did not say I agree in any way to those, Sarah. You did not say, okay, I can meet on this date, but be aware it might change based on my criminal case. You did not do any of that, which is why it is seen that you did not want to do mediation. Just like this, your 33-page bullshit.
Would the joint stipulation have been received prior by the respondent for collaboration and review? The supplemental petition to modify would not have been made, causing a ripple effect.
What are you talking about? Okay.
Of violations of her due process and constitutional rights. The respondent was never given a lawful opportunity to participate appropriately, as with many other missed opportunities caused by the petitioner and his counsel's undeniable wrongdoing against her throughout this case.
It is deniable.
Undeniable. I know, and everyone knows that had I had known to be prepared, I would have been. Just because you say it doesn't mean it's true.
She always knows. She always knows how to do everything, and she doesn't know
what to do and how to do it.
Yeah, what?
Except in the last 5 years.
This, that, and the other. So there's this.
Two, regarding the respondent's.
Yeah, I mean, aside from this.
Aside from the supplemental.
Right, whatever that is.
Just.
Can you just tell me, like, how, like, what I should, like, what's gonna, like, what I should plan on? You
want me to tell you how to not be charged with a crime, Sarah? I mean, I don't know.
Are you trying to make me feel worse?
Trying to make this worse? Know that on my son.
Yeah, I'm leaving it at that.
In her incarceration
Please?
and the time up to present, the only, quote, chaos
Please
generated has been from the
understand,
petitioner and his
not
counsel's
intentional.
uncooperative,
I don't want to tell
disruptive
you.
attitude, which has made this entire process more
See, now I feel like you're trying to feed me.
arduous and worse for herself, their son, and the court. Both had committed perjury on multiple instances in writing and verbally to the court,
Yeah, you don't list them out, though.
ignored the judge and respondent, and continued to be part of the problem instead of the solution, which the respondent has ceaselessly attempted to generate to be a part of her case completely. From her cooperation, attempted solutions, and ongoing answers, resolutions and provisions could have been made in avoidance of trial, all costs included, and continued disruption for all parties. Many items could have also been solved with the
Let her finish the sentence, and then
meeting of attorneys and unrepresented parties been scheduled as ordered.
What evidence is there of that, Sarah? You have not agreed to a single thing in this entire 33-page document. You have agreed to nothing that they said in their pretrial statement. So what could have been resolved? And well,
She's
of course,
always looking for solutions. That's who she is.
her answer is that she's such a skilled negotiator. She would have been able to,
Get LWAP.
wear them down, being like,
Yeah.
She would.
Did Brian have any witnesses in his thing?
I don't remember. I can look it up.
Yeah, I don't know if anyone knows. Like, I'm not sure if he thought it was that kind of party, and she was just like, "Well, watch this."
Well, she would have talked his lawyer into suicide. She'd be like, "You need to kill yourself. You need to kill yourself. You need to kill yourself." No, there's no witness listed in his.
Yeah, I didn't.
None at all.
It's not that.
Oh,
really-
wait. Sorry. I missed it. Yes. Who do you think the two witnesses they list are?
His son?
No.
No, he's not dragging him into it. I don't know.
Himself and Sarah. The only two people that are relevant.
So the answer is no.
Yeah,
Really.
no.
Not the way she did. Like,
No.
you could call Eli and Kim.
She listed her brother, right? That was the only third person she
I thought
listed.
there was one other person, but maybe.
No, she listed Brian, herself, and Philip.
Okay. Philip's finding out about that right now, watching this probably.
He's like, "What? I got summoned?"
Yeah, Philip who?
Okay. Robin, the ADR Pro. What does ADR stand for, Robin? If you could help us out, that those that are less than, that are not as, yeah, she was diagnosed with cancer, right? She doesn't know her availability. She might be dead.
Or Jesus himself.
I am a professional mediator, and I would not ever attempt to mediate this case. Sarah Boone would need to be there in good faith, and that does not mean seeing herself as Jesus's best friend. Well, you're saying her faith isn't good?
She sees herself as Jesus, not Jesus' best friend.
Okay. Alternative dispute resolution. That's what ADR means. Got it.
Thank you.
Cool. Thank you.
This is a further example of the petitioner and his counsel's added, quote, chaos, and not the
She
respondent.
hates that word.
Respondent has been transparent, properly corresponded when prompted.
Now, all you do when you correspond is give a bunch of questions and a bunch of baseless accusations, just like this letter, just like you said above, like there are numerous perjury or lies, right? Where they're slandering you.
Provided innumerable solutions, vigorously attempted to be included in this.
And you have not provided one solution in this case other than I want my money. I think that's the only solution. Give me money. That's the only solution she has.
Send me money.
I mean, she has been specific in the way she wants them to be paid, $300 at the beginning of every month. And she wants to make sure that the parenting plan is not only exercised, but, altered in terms of her favor based on sanctions that the petitioner should have against him. But she should know by this point that the legal system is not as stupid as she hopes they are, right?
Yeah, I know she should know a lot of things by now. Like the fact that Brian has a lawyer and she doesn't, and that anything his lawyer is doing is going to be legal.
I mean,
Case by the petitioner and his counsel and cooperated in every manner possible throughout the entire.
And this is how we know she wasn't a good student. This is exactly the kind of same argument she would give whenever she got a B or something, or a C or a D. She would say, I'm ceaselessly and profusely exercising my best intentions, even though I am not a trained writer. I do believe my efforts will show themselves, and I think that my grade should be an A if you reconsider this, how this test was given, and all is kind of, yeah. Hello, olive oil.
And she never reads anything, and I'm sure that has not changed. I mean, I'm sure it was the same in high school.
Just got to read that Bird and Bloom, though. Birds and blooms, bees and blooms. Better blooms and gardens.
The petitioner has and still does not include the respondent in their filings.
Now, I don't believe this is true. Number one, that would be ex parte communications if you just send this to the court. And a lawyer, here's the thing with law school. I think, maybe I could be wrong. Or ADR, did you say your law degree, right? ADR. So, it isn't in your best interest to toast your law degree by violating bar ethics or by violating court rules for a certain case, because you need that bar license to continue doing other cases, right? You can't just act bad in one case and then expect it not to impact the rest of your life, right? So sending correspondence only to the court would be such a rookie move by a lawyer. It's something that only pro se defendants do, such as Sarah, where she writes just a letter to the court, right? Hey, dear judge, all of her letters, which get entered into the record because Honorable Judge Steen, thank you for your selfless sacrifice and your
Honorable Judge Jackson,
your commitment to truth and justice. And seeing that I am trying in every way, shape, and form, whatever. But the problem probably is, Sarah, most likely, that it's hard to get mail regularly in prison where you are. And that's not the lawyer's fault. They can send a copy to you, and that's all they are obligated to do. Your address, right? And whatever happens at the prison, it doesn't mean that they're in violation. But so I don't believe any of this shit here where she's saying
no. There's plenty of time in between all these things.
Yes. And
she made it so that she had to get more mail because she wouldn't acquiesce with anything. Like,
okay, I'm right about lawyers and ethics. What was I wrong about?
I'm kidding. Interesting take you had there.
But I mean,
everything else.
Robin, everything else in the stream has been 100%
that you were right about.
But I finally landed on something correct. But yeah, there is no. If you send something to a registered address, right, you might not get proof of delivery for proof of service, right, when the trial comes. But the fact that she's referencing all the stuff that she doesn't get means she is getting it. But yeah, I don't. Via email. Where's this email, Henrietta? Where's this email from Henrietta warning his counsel via email in another of their attempted filing state will be stopped and not accepted if they continue to not include the other party, which is the respondent? How? I don't know.
Robin says you've been right throughout.
Correspondence with the court.
I don't know if Robin's a man or a woman, but they said I've been so right.
Well, what does that matter? Well, you think if it's a woman and a man makes
no, I'm saying if I can't say he or she.
Oh, I see.
Robin, are you a man or a woman? You don't have to tell us, but
you can just say they. That's how the world is now.
Maybe they want it to be.
But then I'd be like, they. It's one person.
In this case, as a whole, the respondent has contacted the petitioner asking her why exclusion continues, and his counsel via handwritten letters with no response.
Hey, we're halfway through the 20th page. I think that is not going to happen because the judge didn't bother with the GAL, right? The judge doesn't need the input of the kid. That's normally what would happen, right? You have the GAL. Well, you didn't have to put all your pronouns. You just say she. I'm bad with pronouns.
Where can we get that thing? I want to see that Henrietta coffee thing.
That email? Yeah, I mean, strangely, it's not in the court record.
Yeah.
It's weird that she got copy of correspondence from the judicial assistant, which isn't in the court record, yet she cannot get copies of the submitted items to the court, right? It seems a little suspicious that she's getting copies of private conversations, but not getting official submissions. Seems like it's bullshit. No, it's not my spotless head of a rep. I'm just saying I call everyone dude. I say guys a lot. Come on, guys. Even though I worked with predominantly females for most of my life, I'm like, guys, come on. Yo, come on, bruh. It's going better than I thought it was going to be. Taste the Rockies. Flag. Rock, flag, and eagle. So you hear me? It's so good. I get a little Boilermaker. Oh, there goes the cap. I don't want to kill you. Do you feel in charge? No, brother. They expect to find a body. I gotta use these clips at the beginning. Yeah, she isn't getting a right. Let's go. It's prison stale mail. It's not his lawyer choosing to risk his practice, or his right to practice law.
Fisher has,
like, you know what? I gotta not provide this to her because if she has time to prepare, she'll smoke us.
Still does not include the respondent in their filings, correspondence with the court, in this case as a whole. The respondent has contacted the petitioner asking why her exclusion.
Yeah, because I'm pretty sure if I said ladies, I'd be called sexist. Ladies, listen. Like, what are you saying? Ladies.
Continues, and his counsel via handwritten letters with no response. The judicial assistant, Henrietta Coffey, previously warned his counsel via email to 2723 in another of their attempted filings.
What's up, no
stating
chaser?
It will be stopped and not accepted if they continue to not include the other party, which is the respondent.
Skanks? I should say skanks instead.
Hey, bitches.
Oh, what's up, bitches? We're just on this work call here. All right, I wasn't paying attention. I got to back it up.
Via handwritten letters with the petitioner has and still does not include the respondent in their filings, correspondence with the court, in this case as a whole. The respondent has contacted the petitioner asking why her exclusion continues, and his counsel via handwritten letters with no response. The judicial assistant, Henrietta Coffey, previously.
Yeah, he's supposed to be at Latin school, but I've also heard rumors that he's actually out with the Moores, Dr. and Mrs. Moore, with Kayla on some cruise. So he better not be, because if he's thrown away that tuition we paid for the Latin summer school.
Yeah.
Jesus.
They warned his counsel via email to 2723 in another of their attempted filings, stating it will be stopped and not accepted if they continue to not include the other party, which is the respondent. She also, on more than one occasion,
I like how she pointed out the other party is the respondent to the judge. Again, Sarah, we know all this.
Agent has been unfairly ambushed by trial from no inclusion by the petitioner.
What trial? There's one hearing. The trial has not happened yet, Sarah.
She believed she was being transported for case management conferences she would request from constant exclusion and having no status of her case to be properly prepared to defend herself. An attempt to represent herself as pro se, which petitioner and his counsel advantageously tried to have control over. To date, petitioner and his counsel do not include the respondent, take advantage of her circumstances, and discredit her truth in her pending appeal that is in process to disprove her charge and bring forth her proposed release.
Oh my God, that was a mouthful, but discredit her truth in her pending appeal. There is no truth in your pending appeal. Technically, we haven't even seen an appeal because your appeal attorney quit, right? He probably was like, I can't find anything in here where she didn't just... I mean, I don't know how appeals work. Do you file an appeal regardless based on like maybe Robin can help us out here. Robin, is it you just file an appeal for a matter of filing the appeal? Or does everything that you want to appeal in the future? Because I know there's all these, or they say there's appeals that go on for decades, right? Does everything have to be in that first appeal that you could appeal like to a higher court? Or can you later file, I found out this person was actually over here based on new witness testimony, and that's an appeal issue, like something you learn later? Like, how does that work with appeals? We need you to tell us, even though if this isn't your expertise, go ahead and make it up and let us know.
In their intentional exclusion and perjury,
perjury. So the fact that they didn't say she's appealing because they're so scared to mention it, right? That's what she's saying, right? They're so scared to mention she's appealing, though. She's appealing her lifetime in prison.
Yeah, because everyone thinks that appeal is going to happen. That's really going to be...
Right, that's what Sarah says. You are going to... My appeal is so solid.
Yeah,
it is
absolutely.
So solid.
Also was her court case, so I don't know what happened there.
It's so solid that I'm going to get out, and they don't want to let you know that. And it's perjury not to have mentioned it.
Yeah.
They're saying I'm in prison for life just because the judge said I was going to be.
She's not saying ask so-and-so and so-and-so, and they'll tell you, whatever. Like, she's not naming names. She's just saying it just is, obviously.
All right, Katie says if there's new, fresh, compelling evidence, you can appeal, but it still has to have legal grounds. Obviously, it has to have legal grounds, but are you saying, like, if it was something that could have been known that's more what I'm asking about. If it's something that would have been known at the end of the trial and you don't appeal it, you can't appeal it later, is I guess what my main question is. So maybe that's why they include everything. Do you throw the entire kitchen sink is what I'm saying?
Yeah.
Just to make sure that everything's there.
Trial, for sure.
Right. Like her not...
Counsel, the evidence, the everything.
Not getting a continuance once her new lawyer was in there, right? Including the video of her confession, even though she was just told to go down there to pick up her phone, even though she had written questions, all that kind of stuff.
Right. Yeah.
When she was tricked to go that, this is all trick.
So you tricked me.
Because Sarah knows.
She would not shut up. I mean, she had plenty of time and my guess would be that Brian told her the night before, you should get a lawyer. And she was like, no, I got this. Brian.
Kathleen, yeah, I haven't seen anyone. I mean, I don't know that I see a whole lot of people say that appeals will go through on many cases.
Chance in a good situation, I think.
Okay. Robin says, it depends. A lawyery answer. That's fine. Technically, the appeal must raise everything, but once in a while, there are later discovered grounds which could be appealed by a special writ like habeas corpus. I don't know what. Yeah. I know what habeas corpus is. It's something like you got to be tried, like you can't be held without a charge or something, I think. Or there used to be a body. This is this Latin stuff that Suma and Derek love the shit out of. Okay, so tell us. What does it mean, Suma? What is it?
Oh, I don't know. I don't know what it means legally, certainly.
Oh, that's right. Both you and Derek mentioned last night, you both failed Latin.
Well, he didn't really fail, but I did. But I only failed the last year I took it, not all the years before.
Robin K., I have another question for you. I was trying to get this out of Shin at the time, who's also a lawyer, on episode 3, where we covered... episode 3, which was the series finale of Sarah Boone. Here we are, like a dozen or more episodes later. If the judge doesn't make any sentencing comments, right, and just says it's life in prison, right, does that make it easier, harder to appeal it, right? Because he doesn't say anything. He doesn't. If you make comments as a judge, let's say like the judge in the Brian Kohlberger trial, where he made comments about his own personal beliefs and that kind of stuff, does that an appeal issue that could be brought up? Maybe not, but by saying nothing, does it make it harder to appeal? Just a question. I always had that question. If it's harder to appeal when the judge says no comments and just pronounces a sentence, because there's nothing to, you can't say, well, he based it on this. No, he just said life in prison.
Should not be responsible for any supposed attorney's fees incurred by their attempts to continuously sabotage her life.
And why is it supposed attorney's fees? They are attorney's fees. She's intimating that he's really doing a pro bono and this is a scam.
Lawful attempts to be successful in this case. The result of their growing unnecessary cost is due to the petitioner and his counsel being uncooperative, stating ongoing untruths, false accusations causing innumerable violations of the response.
Okay, that's what I thought, Robin. Yeah, he of course does have the right to remain silent. So, yeah, that's why I figured, in my personal opinion, this is just my opinion, I figured he didn't say anything because no matter if he said anything, Sarah was going to have something to punch against. But when you say nothing, she has nothing to fight against about. She cannot write letters on nothing. So,
yeah, it's so smart not to say anything.
Yeah.
Proper, lawful inclusion. Their, quote, acts and failure to act, end quote, ethically, lawfully, and truthfully necessitated their own attorney's fees.
Well, okay, so actions and failure to act. That's again another quote out of his motion, right, where she's stealing it from there. But not acting ethically, lawfully, and truthfully. Again, that would be grounds for disbarment. I'm pretty sure they didn't do that.
All attorney's fees were and are self-inflicted by the petitioner and his counsel. Case law, Florida Statute 6116, blah, blah, blah.
Corpus delicti is the one I'm thinking of, where they're like, where's the body, right? This is the sob sit. This is a stupid sob sit. I think there's nothing dumber than a sovereign citizen, but just because.
I don't think you're going to get many arguments here.
Yeah, just because of it's the dumbest because, if you're flat earth or whatever, your belief in the flat earth isn't necessarily destroying your life. Sovereign citizens, you are destroying your own life by this. You're making everything 10 times worse.
Blah, 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 blah. Resolutions. 1. Respondent requests from the court to deny the petitioner's proposed award of any attorney's fees due to their intentional and strategic exclusion of the.
Yeah, that's what I'm saying, Brian. Robin, not Brian. I'm thinking Judge B. But I also think that those appeals don't work. But given Sarah's proclivity to write letters, right? Lori doesn't necessarily write letters. She just does TV interviews and laughs like an idiot. Did you see the interview from the last interview that one reporter does that has done 3 interviews with her after her trials? It was the one right before her sentencing.
Nate Eaton, you mean Lori or
not Eaton? She's a female.
Oh yes, yeah.
Like Christina or something, right? But she's sitting there holding up a photo of her in Chad. Like, hold up a photo of your kids, you monster. Like, if you want anyone to feel, nobody cares about you and your murder accomplice.
I mean, on the contrary, he is just.
He's so ugly. He's such a toad.
I hate him maybe more than I hate her, honestly, because he managed to kind of orchestrate. She saw to it that he orchestrated this whole thing.
He looks like this.
Oh, he's such a lump.
No.
Ugh, disgusting. She had to be married to him for all those years just for that to happen.
Candace, okay, I can't debate that, Candace. There is the fringe on the flag making it the military admiralty court.
Yeah, that's a very good point.
In their relentless attempts to control this case, including the court by overruling and ignoring, committing perjury too, so the respondent is accused uncooperative and defiant. It is the petitioner and his counsel who are so.
So, catch what she's saying here?
Respondent requests an award of attorney's fees due to financial hardship and loss caused by the petitioner's failure to pay alimony with active agreements, court orders, and without.
Oh, I did back it up farther. But she wants attorney's fees. She wants her own compensation. Again, she wants that $15,000.
Counsel who are so.
No, wait. I mean, Sarah.
This case, including the court by award of any attorney's fees due to their intentional and strategic exclusion of the respondent in their relentless attempts to control this case, including the court by overruling and ignoring.
So I'm not sure if she's trying to say this in the way she's phrasing it, but it looks like she is saying that the court is also complicit by overruling and ignoring, because the court is the only person that can overrule something. His attorney cannot overrule anything.
He doesn't understand anything. I know.
Committing perjury too, so the respondent is accused uncooperative and defiant.
This would be another great place, Sarah, to put what the perjury is.
It is the petitioner and his counsel who are so. 2.
I just love this part.
Respondent requests an award of attorney's fees due to financial hardship and loss caused by the petitioner's failure to pay alimony with active agreements,
I want attorney's
court
fees.
orders, and without modifications for
She tried
over
that in
five.
her trial.
Yeah, of course.
Just the balls on her.
But it's based on the petitioner's failure to pay alimony with active agreements, court orders, and without modification. What do you think we are here to do, Sarah?
Years. 3. Respondent requests sanctions to the petitioner's counsel for his unethical treatment to her as a disadvantaged party in this case, continued exclusion, confusion, defamation so she cannot properly defend herself, encouragement of the petitioner to remain uncooperative.
Now, you could easily just defend yourself against defamation. You could present the truth that is the opposite of what they're saying that's a lie, right? So you would put that here again. And I don't understand how continued exclusion, confusion. Is it their confusion? Because these are acts that they're doing, right? So they're confusing. Like it'd be confusion of her, not just confusion. Their ongoing continued confusion. You get what I'm saying? It's a grammatical thing I'm getting out of here, like with her stupidity in the sentence.
And blatant defiance to the court in ignoring orders, undermining its sole authority.
Again, the court, you gotta pay attention here. Brian and his lawyer are doing a runaround on you. They're just ignoring you.
Age 6, H, trial exhibit / witness.
No, I'm not going. It's like it's not cheap. It's like, well, I mean,
In Denver, right? I don't want
it's in Denver. Who'd want to go to Denver? But where the Broncos are those losers after the Seahawks destroyed them in Super Bowl 49. I think it was 49. But it well, I don't know about the entry level tickets, but the ones that were left, they were like $1,000 or something. It was not cheap.
It's not inexpensive for sure.
And if I want to see a bunch of criminals, I just go down to Seattle.
I'd have to go outside my apartment.
Not
Oh,
dissing
not
anyone.
my building, probably.
Not dissing anyone who's going. I just,
I would like to go. I might go next year, depending on where it is.
I'm kind of awkward in person, so not really a people
Oh, me
person.
too. I mean, I'm definitely going to embarrass myself, but what else is new?
Says H, witnesses. A witness list giving names and addresses of all individuals who may be called by each party to provide testimony, including
I don't understand why she includes the definition here. She's just
impeachment witnesses.
the court knows what their own instructions were. Why are you putting the definition in here? On his I think it's because it's on his, right? So she was like, okay, I'm gonna put it in here. But she doesn't do that anywhere else. So You know what I'm
Only
saying?
when
Like,
it bothers her.
And expert witnesses. 1.
Me-
Sarah.
maybe it's legally required. Maybe Robin can help us. Robin, are you supposed to do that?
K.
She wouldn't
Boone.
know if it was legally required. I don't think. I mean,
Respondent. Former wife. Mother of minor child.
Well, I mean, but the reason she's doing it is because his lawyer did it. That's what I'm saying.
Location. Ocala, Florida. 2. Brian C. Boone. Petitioner. Former husband. Father of the minor child. Location. Gainesville, Florida.
Okay, maybe it was the lower one. Wait, it's the entry ones that are left then? Like, I couldn't remember which way it was, but it was just $400 seemed like that's what my plane ticket to Orlando costs. So
Philip Paulson. Brother of respondent. Location. Altamonte Springs, Florida.
I'm sorry if I butchered that. I'm used to people butchering names from the state of Washington all the time, like Puyallup. I wish I just had open line. Just somebody, whenever they're doing these videos, because there's lots of videos on Washington, right? Just ask me the name. I will tell you. Puyallup, not.
you can also search it and have the voice things tell it to you.
Spokane, not Spokane. Yakima, not Yakima. Just
Florida.
I don't even know why Yakima is a hard one. That's a brand. Or no, it's not a brand. It's like Yamaha, but Yakima, whatever.
H. Trial exhibits. E. A detailed schedule.
If anyone needs to know how to pronounce a city in the Pacific Northwest, go ahead and message me on my channel. Okay.
Of all photographs, exhibits, and documentary evidence that a party proposes to use, including impeachment and expert witnesses. The schedule should include enough information to identify each specific document. General categories of documents are not permitted. Composite exhibits are permitted if they are specifically identified.
So this section, she's going to say all this stuff for trial exhibits, right? But she's not going to be able to produce any of these things.
Of course not. And
So just to give you an example, in his response, right? He lists two things. Okay, so a detailed schedule for, right? This is item B. He says, what does he say? He says, petitioner's family law financial affidavit. Right, so that's all he's doing. The financial affidavit they already submitted. That's all they need. And then all exhibits should be pre-marked before the date of trial. Instructions on how to properly pre-mark can be obtained through the clerk of court. And he said the petitioner will have all exhibits presented pre-marked before the trial date. Meaning they're going to bring them. She's just listing out, okay, this is what I need. This is what I want. You know, this is what should be there. This is where have we covered the part of the judicial, I can't think of the word. Judicial. I mentioned it in the intro. Where the judicial notice. Is that what I'm thinking?
I don't know if we've discussed it.
You take judicial notice, right? Like today is Tuesday, right?
Mm-hmm.
Or the 18th was Tuesday, right? Just take judicial notice. We don't need to lay grounds for that or present evidence, right? It is what it is. This is where she should be listing all these in judicial notice that all these court records should be part of the thing. But you see, look how repetitive it gets down here where she's not specific, where instead where she lists dates all above of specific dates and like month, day, year. Now she just switches to years, making several of these items redundant because you're not specifying which one it is.
1. Marital settlement agreement
moron.
signed by both parties, 2018. 2. Hearing plan signed by both parties, 2018. 3.
I think she won't have any of the evidence on court, and since she's going to be there telephonically, I'm imagining it's going to be a bunch of like, well, I would like, you know,
If you don't mind, please.
I tried to properly prepare as best I could, but due to limited resources and the inability to look up any copies or obtain copies due to lack of financial resources due to the petitioner, I was not able to get copies to submit to the court. And I'm asking the most expedient way to get these in as they could be. And the judge goes like, well, you didn't submit them earlier. Like, okay, yes, please. But I would like you to take understanding with your full judicial knowledge and understanding my ceaseless efforts to, it's just going to be this like nonstop. Oh, I'm so looking forward to it.
Parenting and divorce certificate, Brian Boone, 2018. Or parenting and divorce certificate, Sarah Boone, 2018. 5. Final judgment of dissolution of marriage, 2018. 6. Supplemental petition for modification of
Ravina
final
was
judgment,
in
summons,
LDS?
2022. 7. Respondent's answer to supplemental petition for modification of final judgment, notice of filing, 2022. 8. Petitioner's verified petition to relocate, summons, 2023. 9. Response.
So Ravina, you were in like one of the offshoots then? Because I know a lot of Mormons that aren't like in the Lori chat. I mean,
There are like 4 of them, like, the last I counted.
yeah, it like the offshoots, like the polygamy offshoot and all that kind of stuff, or like the what's his name? Jed. It's like Jed. It's like 2 first names is his name. Jed Daniel, like Jed Daniel or Jeff.
Oh, Jeff, Warren Jeffs.
Warren Jeffs. That's what I'm thinking of. Yep. Thank you. Yeah, Warren Jeffs and this kind of stuff.
Yeah.
You wouldn't join I'm Native and they did sweeps. Oh, okay. Well, that's terrible. Well, I'm glad you were able to avoid that.
Its correspondence to judge in motion for contempt, 2023. 10.
Yeah, she could. She could say that she is adopting the petitioner's exhibits, and then anything he isn't listing, much easier to deal with than duplicate copies of things. Well, but they didn't list all these items that she wants in here. But this should have been just judicial notice, right? Judicial notice of court record, right,
We'll
Robin?
also say that those exhibits have been altered, or
Robin, also correct me if you're a pro se, like if you just say, I want you to take judicial notice of these motions and then provide more specific instances than Sarah does, because she just keeps listing year after it. Do you have to pay to get those copies, or you just, you know what I mean? Like, should they be able to pull them up? I would think they'd be able to pull them up if they're already in the court record, but I don't know.
Respondent's correspondence to judge regarding motion for contempt, 2023. 11. Respondent's OCCD commissary records, 22520 to 2124. 12. Petitioner's certificate of compliance with additional updated mandatory disclosure, 20.
No, I know they're irrelevant to the matter. I'm just saying, like, can you just request, hey, take judicial notice of these motions that are already on the record, or do you have to bring additional copies? Like, procedurally, that's what I'm asking. Not that these are irrelevant at all, because they're not.
25. 13. Petitioner's family law financial affidavit, 2022. 14. Petitioner's family law financial affidavit, 2025. 15. Petitioner's account statements, 4/26/24.
Okay, yeah, the judge isn't pulling them up. Each side must provide the orders. But what I'm saying is, like, if you provided, like, she's providing blanket years. What I'm saying is, if you provided the specific date and you say these are on the court docket, right? Not the judge is going to pull them up, but the judge's assistant or something. But you know, what I mean? That's all I'm asking. Like, if it's already in court record, what's the point of bringing a printed copy if they have the record? Because why trust a copy that comes from the outside? Does that make sense? Like I'm not going to take somebody's PDF that they sent. I'm going to pull up the original record because some people could like pull some shady shit. Or that makes sense? Yeah, they could take judicial notice of the items in the court docket, but does that mean you also have to provide the copy of them? That's what I'm asking, Robin.
3/27/25. 16. Respondent's family law financial affidavit, handwritten, 2025. 17.
That's already in the record.
18. Petitioner's mediation correspondence, 2022. 18. Respondent's answer to petitioner's counsel for mediation, 2022. 19. Petitioner's motion to dispense mediation, 2022. 20. Petitioner's notice for trial, 2022. 21. Respondent's correspondence to judge regarding non-payment of alimony, parental alienation, 2022.
Thank you, Robin. Okay, that's good. Now, hopefully, Robin is a reliable source, or else I'm going to have all these seeds of
Either way, they know
incorrect information planted in my brain, which is fine, but they're going to exist forever now. I'd be like, no, you're wrong. Robin told me in my chat that you are wrong.
2. Respondent's correspondence to judge regarding non-payment
Oh my
of alimony.
God. You see, you're so pretty. Lol, I'm straight and married, but you're always so gorgeous, and I just wanted to tell you that.
Thank you very, very much. That's
Well,
all that matters to me, really.
I just gonna say I very rarely find the need to say, by the way, I'm straight and married.
Parental
When I say a man is gorgeous, like Ryan Gosling.
alienation and request for case management hearing, 2022. 23. Respondent's correspondence to judge regarding non-payment of alimony, parental alienation and request.
Whoa, Shiesty Avengers, Ashton, welcome. Thank you. You're about to get some knowledge dropped on you about the worst human being on the planet. This is something that has never happened before on that planet. What? Okay, I'll give you a wrench. Hold on.
For case management conference, 2023.
Who else wanted a
24.
But the number one rule of wrenches is don't remove anyone.
Respondent's correspondence to judge regarding non-payment of alimony, parental alienation and request for case management conference, 2023. 25. Respondent's correspondence to judge regarding non-payment of alimony, parental alienation in motion for case management conference, 2023. 26. Respondent's request for initial disclosure from petitioner, 2024. 27. Respondent's correspondence to petitioner's counselor regarding exclusion.
You just see above, right? It's the same thing listed 3 times with the same year. Like, Sarah, what are you doing? How do you list these out? This is why I feel like this is not it's not her typing it up, right? Because when you see it like this, when it's all listed together, maybe in her handwritten thing she said there's like this 2023 times 3, and so the person converted it to, okay, this is 23, 24, 25, because I got listed item by item. But it's so stupid.
23. 28. Respondent's correspondence to petitioner's counsel advising appointed contacts for inclusion, 2024. 29. Respondent's correspondence to petitioner regarding exclusion, 2024. 30. Respondent's correspondence to petitioner regarding visitation with applications, 2, 2025. 31. Respondent's witness letters from criminal case, 10, 2024. 32. Current interest rates, alimony arrears, myfloridacfo.com. 33. Personal property car estimates, 4, multiple websites. 34. Certificate of destruction, personal property / vehicle, FOHSMD.gov. 35. DOC canteen items with current pricing fluctuate.
Well, that's because America is the greatest nation to have ever existed in the history of the universe or the world.
With vendors. 36.
It's a universe.
GTL communication current pricing, phone calls. 37. JPay communication features and current.
Tell me anywhere. Tell me another country you'd rather live in. No.
Pricing, video visits, pictures, messages, stamps, diagrams, more. Exhibits attempted by respondent to submit. 1.
I love this section. Let me just remind you of all this shit I've tried to get and didn't get.
PD and DOC.
Mexico. Canada. Okay, now I know you're lying because A, I don't want to be kidnapped by the cartels. B, I don't want to hug trees and drink maple syrup.
Yeah, he's not like the rest of us. He wants to stay right here and wave his flag. Although I am.
Plus, they use the sugar in pop in or soda in Canada and doesn't taste right. I've been to Mexico once. I managed to come back, but when I was there, it didn't like it didn't like wow me with like, oh.
I'll tell you this, I would never go to Jamaica, just saying. So
well, I've been there twice.
I know.
Well, I'm just saying, like when I went to Mexico, like there was like rusted out cars along the side of the highway.
I don't like getting murdered, so that's why I'm not going to Jamaica. That's all I'm saying.
Well, yeah. I mean, they don't have a murder affinity for blonde men.
Recorded phone calls. Denied. 2. OCCD and DOC tablet messages. No responses. Denied. 3. Copies of case documents from clerk of court. Former 14.
Whoa. What is this?
Oh, he's fine. Hi.
It's an ironic comment.
Yeah.
Okay.
I was wondering actually where he was. I haven't seen him in a minute.
All right. Just so everyone knows, I love ironic comments, but you have to be clear that it's an ironic comment. Put the little smiley face, laughter face after you say the comment, because I don't know all the time.
No, I know.
I have to flesh it out. I'm not saying for your channel, but just like for my channel.
No, I know you're very protective about, and I like that about you.
Yeah, and if anyone cares to wonder, if you insult my co-hosts, I'm not going to agree with you and be like, oh my God, you're right. I don't like them anymore because of the comment you left. Just don't say anything if you want to watch, or else I'm just gonna remove you. I had to remove somebody the other day, right? I sent Suma, I was like, well, we got a second removal here. There's been only 2 removals in the history of this channel. One was the guy that left me that message on the first live I did, the one where he was just going insane. And then 2 was the person making comments about Suma. I'm like,
the one who said I was autistic and I took it as
no, he said more than that. He just
and
there were multiple. At first it was like, okay, this could be a joke or whatever, but then responding back, and then he just kept going. I'm like, okay, no, not gonna happen.
Dollars.
No, I do assume all comments are sarcasm. That's why I have to, but people are very self-revealing, right? They will continue to make the comments saying no, I really think this person is trash or something. Okay, got it.
Yeah.
Correspondence.
Oh shit. I clicked.
Responses. Denied. 3. Copies of case documents from clerk of court. Former $14.
Right?
Unpaid. 4.
It was great.
Petitioner's complete financial documents / records.
And
Denied.
Derek is the straight man. He's
good.
punished by all. The other thing that people mostly don't understand is I rarely tell Derek what the content of the stream is going to be beforehand. So he's going in blind every time, mainly because I want his straight reaction. But he hasn't rehearsed or investigated anything, and I want the newcomer. I want his reactions. That's what I did. But it's also fun making him feel awkward when I create things like this.
Five. Motion for counsel to be appointed to respondent. Denied. 6. Motion for guardian ad litem. Denied. 7. Letters to former counsel for irreplaceable case documents to be returned for trial. 4. No response. 8. Request.
Didn't the judge deny her motion?
Bro Meow goes. Huh?
Wait, what were you gonna say?
Bro Meow goes.
No, yeah, Bro Meowgos would be one, but it was Bromigos because of
yeah, we know.
Cinco de Mayo. Is there a cat day? Is there a universal cat day? Maybe we could do.
Sure, there is.
I'll have to Google it. But didn't the judge deny her motion as irrelevant when she filed the motion saying, "Hey, Owens, you got to give me all the stuff back," and I'm pretty sure it was denied.
Yeah, I'm sure it was.
Your beard is dumb.
Is that how we do it? Yes, that's right.
No, it wouldn't be just my beard is dumb. It would be you continue to say, "Why don't you shave your beard? I hate your beard."
Why? Why do
Great.
to classifications department regarding visitation. 8. Not processing to date. 9. Letters to petitioner regarding visitation applications. 2. No response. 10. Tablet messages, DOC, to petitioner regarding visitation. 18. ongoing 8 months after court orders to submit. No response.
Okay, that's problematic because my anniversary is on August 8th, and
Well,
I
you have to make a choice. And
I'm going to choose my anniversary over International Cat Day.
11. USB drive from Clerk of Courts for trial. Waiting for 2 months to view from
No,
GOC.
I understood she was kidding.
7 requests to classifications department. 12.
Yeah, you got to repeat the same insult over and over, and then like despite my response of saying, well, okay, but I like my beard, so I'm going to keep it. You keep going, no, you got to shave that thing. Like, well, I'm not going to.
And that person never has a picture, by the way. It's always like a letter or, you know.
Yeah.
It's like, well, let's see what you got going on.
It's always a letter like Kathleen here.
Yeah.
Who knows who Kathleen
but
really
Kathleen's
is?
not coming out of her face being like, you're autistic and your beard is stupid and, you know.
Kathleen, why did you stop hiding behind that letter? All right. August 8th is Universal Cat Day. Thank you for the super chat. We will go ahead and
Someday, baby, you and I are gonna be the ones, so hold on. We're headed for a better life. Oh.
Oh, wait, no, now somebody's saying October 29th is Cat Day.
Uh-oh.
Oh, interesting. Well,
Transcripts from case management hearing 9/19/22 stating petitioner to continue payments and constitutional rights violations from judge unpaid.
Right.
Respondent graciously requests the court's
based
understanding and
based on what Robin said, this is not it's not unreasonable request to just, but that's where she should have put it under the judicial notice section, which she didn't.
consideration in the crucially limited supply of her exhibits, seeing her good faith efforts to obtain many others but unlawfully withheld financially from non-payment of court-ordered alimony from the petitioner, unresponsive parties, and denial from the court due to her inexperience as an attorney in representing herself pro se.
What's the number one thing that all judges say when you say, hey, you're representing yourself pro se? What's like the first thing they say? You know this?
Not a good idea.
Well, beyond saying it's not a good idea,
I don't know.
say you're not going to be treated any different than the other counsel, right? Who has had many years of law experience, right? You were not going to receive any special benefits.
Too
Now,
bad, right?
in
Don't do that. Good luck.
in practice, they don't stick to that, but putting it in here like, hey, I'm not an attorney yet. Oh, really, Sarah? Oh, couldn't tell. But
First and foremost, I have no idea what I'm doing.
yeah, first and foremost, I don't know what I'm doing, but I know I'm right.
But I have been writing letters to and about my lawyers and how terrible they are, and to the judge for the last 5 years.
String of 12 or 11 terrible lawyers that didn't know the law like I did, because the one thing is she thinks that there is an outcome that there. She say about Cashman, but she doesn't recognize that there can be more than one way,
More than one way, more than one outcome, positive
more than one way to arrive
way to win. I think
at a positive outcome. And just tell her to be nice to me.
I mean, the balls on that bitch. Like, she's not nice to anyone.
Get your armor on. Get your armor on, brother.
Yeah.
She has ceaselessly remained proactive in her parental and representation attempts in achieving truth, justice, success in her present and undermined circumstances to the best of her limited abilities. Page 7. I. Miscellaneous. A. Request for amendments to pleadings. None. B. If this is a modification, filing dates and description of the prior pleadings relevant. Final judgment. Supplemental proceedings, etc.
Rock, flag, and eagle. Red eyes, black eyes, like a doll's eyes. I love making this statement. You know what this is from?
Mm-mm.
Shark's eyes. You ever see the shark's eyes? Dead eyes, black eyes like a doll's eyes. Don't seem to be living until they bite you. And then they roll over white, and you got the screaming and the hollering and then the blood. You still don't know?
No.
It's Jaws. It's the monologue from Jaws.
Oh, I love him so Jaws.
Roll over white.
I mean, maybe when I was a kid, I did, but not.
Not to seem to be living till they bite you. Captain Quinn. Yeah, no, my parents let me watch Jaws 2 when I was probably 5 years old. It was like the ABC Sunday, and I remember it specifically because I was eating a Happy Meal, and I couldn't have been older than 4 because we moved out of California when I was 6, and it wasn't at the end. But that's why even when I was learning swimming lessons, right? All these fools were in the middle of the pool, right? Now, I made sure to be on the outside lane within like arm's length of the side of the pool, because despite the fact that there have been no documented cases of a shark coming through the bottom of the drain in a public pool, there can always be the first. And absolutely. I'm not going to be the free lunch for the shark coming through the drain in the pool. I was deathly afraid of
course.
Watching that. But yeah, that's why I was always trying to stay within arm's length of the side of the pool. Don't seem to be living till they bite you.
1. Marital Settlement Agreement filed May 3rd, 2018 by Circuit Court. Expiration none. 2. Parenting Plan filed May 9th, 2018 by Circuit Court. Expiration none. 3. Final Judgment filed June 15th, 2018 by Circuit Court. Expiration partial April 2025.
Now, Daryl Brooks is on a whole nother level. Yeah. I mean, before I went into this YouTube venture, right, I had all of his trial, like all of it. I have all the video divided up with face tags for everyone in every shot of that trial. And I was working on, I have I made the Daryl Brooks intro, this.
He's much smarter than Sarah, though.
Don't want to get demonetized, but that was the night court intro, and it was called Waukesha Court Waukesha County Court. But there was just so many moments in that trial, and some days I'll get back to it. But he was
really revisit the whole pro se thing in general.
It was just one of those things where, like, it was one of the first, I think, the first real confrontations I've had where you see this person, like, you are on trial for your life, and you are doing all these antics, the sob sit, because I knew what sob sit was before that, but it's just like you're never going to see this really again with a mass casualty event. And the irony that this sovereign citizen argument he never once mentioned that he wasn't driving, he was traveling when he drove over the people. Like, just he wasn't even a good sovereign citizen. But like, he seemed to lack the understanding or comprehension that at the end of this, the judge is going to decide your sentence, and your main protagonist in the entire trial is the judge that you're trying to piss off. Like, it didn't make any sense. But whatever. Maybe we'll cover that at some point.
Yeah. I think about it. It's mentioned every once in a while. People are like, "Oh, do Daryl Brooks," and I'm like, I'm just not sure I can take it. He makes me like. The weird part was he was just so offensive, right? Like, he was needlessly offensive, right? Where Sarah objects about legal arguments coming her way, right? But what's offensive about Sarah is she doesn't know she's offensive because she's that horrible.
She doesn't know she's offensive, but she knows better than to argue with the judge and say you're biased, or I mean, like, directly. Wait. Knows better in this thing to say, like, garbage, which is sovereign citizen. Like that's the first thing. It's sovereign citizen. It's just so stupid.
I'm surprised at how well controlled Sarah is, even physically. The fact that she sits there. She has no outbursts. She doesn't. I mean, when she speaks, she's very unlikable and she says very stupid, horrible things. But she doesn't speak when she's not asked a question. She doesn't. She's not. She doesn't wild out ever.
Yeah, and that's so one thing I've always said about Darrell Brooks is right. That was a inevitable conclusion. He was going to kill somebody, like based on he was either going to, if he didn't do what he did, he was going to eventually kill his girlfriend based on the domestic violence. Right? He has no impulse control, and which is very easily displayed during the trial that he cannot control his
crime.
When he's in front of the jury, he cannot even control himself to put on the presentation of sympathy. Right? He cannot understand. He has zero impulse control, which just means you cannot be out. You can't be out because you cannot make a good decision. You react to everything emotionally, and this was always going to be the outcome. And I think about it in terms of, when people talk about like mitigating circumstances in sentencing, right? When they always bring up like, oh, this person had a bad childhood, et cetera, et cetera. And then I'm like, okay, so would you agree then everyone with this childhood upbringing, we should lock them up because they're going to eventually commit this crime? Because you're saying that based on their upbringing, they had no choice but to commit this crime, which they obviously would not argue for. Right? They would not say, well, you can prejudge them, right? So no, you were saying you don't agree with that. So therefore, people can make different decisions that don't involve killing or harming other people. But whatever. That's my rant on that.
4. Motion for contempt. Filed April 11th, 2023 by a respondent. Expiration continued. C. Any issue the party wants to address at trial that is not addressed above.
Well, the huge conspiracy, Sobson is too far. It's because it's so dumb at its own fundamental level, right? The concept that there is some kind of legal order of saying these certain words that is going to get you out of any legal situation, and the fact that there are still lawyers that go to jail, right? Because the whole premise is that everyone knows about it, but it contains secret because it's all conspiracy to get everyone to go to jail. Well, if lawyers knew this, they would just say these magical words and then walk out free. But they don't because it's not real. And it has never won in court. And they take wins that happen for other reasons and think, okay, well, that proves my Sobsit bullshit is real because they didn't want to unveil the truth. They just bent to this other idea that was brought before as an excuse, and it's just insane.
The respondent's vehicle and storage unit in the petitioner's possession during her incarceration of 2020 to present.
Correct, Hannah Badana. Exactly.
Respondent is requesting the petitioner provide communication history
olive oil.
Oath.
Suma, this is on your channel. I think you're away at the moment. I'll let you read it when you come back.
And current status of
driving because of I just wanted to explain again. Maybe people don't understand what simulcast is. I will say that is the same. So right now I am broadcasting on my channel. Suma is doing the same stream directed at her channel. So that's why we have two different chats where people are watching on her channel, people are watching on my channel. That's what a simulcast is. And I didn't understand it until somebody explained it to me, or I started streaming myself.
It still, so as you know.
Well, I'm trying to explain this. It appears the same to everyone that's looking at either channel, right? I can see all comments from both channels. That's how I can see both. So this is for you.
Thank you so much. I love my olive oil. Oh, yes. Right. Thank you very much.
What do you want me to play? Do you want me to do Sarah Boone or a cat, or you want me to do Dancing Lorne?
Okay.
Oh, actually.
Way Lost in the moment, in each other's face.
It is so embarrassing. The fact
Getting
that
lost in his face is like my worst nightmare.
the fact that Lorne chose to sing a song about a dad and looking at his daughter on her wedding day, the song being sung to her future husband, and that is the song he continues to sing, and he's singing it to his 13-year-old decoy. It's just so embarrassing, and you know that this was his song he sang the entire time because, you know, that's the first song he sang to Kayla on the call, right? He's like, okay, sing to me. And he's like, oh, okay, I got one.
So much in love, you're alone in this place. Like there's nobody else in the world.
Property and vehicle he willingly and voluntarily took responsibility for immediately upon her incarceration. Explain why he lied repeatedly, refused to utilize any of her many no-cost solutions she provided him.
Well, why don't you list out what those no-cost solutions were? Because all I remember is you saying it can be stored on a paid lot, right? And it's stored on a paid lot, and you can add up the tab, and that'll come off my tab, right, of Alimony. I've never heard of a no-cost solution. Other than the only thing it could be is the car being parked at Philip's house, right? What other no-cost solution is there?
Well, I don't know because I'm not nearly as smart as Sarah. I don't have the same like problem-solving prowess as she does.
I guess so.
She always
did not surrender her vehicle.
But good.
She always knows what to do and how to do it. So I'm sure she had some brilliant scheme.
In storage unit to her brother who lives locally and was coordinated to receive and secure, knowing the importance to both of them.
I'm confused because I thought we went over this before. Did we not go over this exact same point earlier?
Well, it bears saying twice.
So this section is titled "Any issue the party wants to address that is not addressed above." It is addressed above, which is interesting that she's putting it down here. But this is
well, she probably forgot for starters.
Well, she basically wants him to say all these things on the record with a signed sworn statement that's going to help her in her second civil trial of you're guilty of this. But you cannot compel somebody to make statements, right? You have the right to. It's called the Fifth Amendment, Sarah. I don't know. You're not familiar with the Constitution, obviously, but these are the most ridiculous demands ever.
Contents from their family who is deceased and to be passed on to her son. Signed proposed documents stating he willingly abandoned respondent's property he personally placed himself as liaison over during her incarceration and was voluntarily responsible for.
Yeah, so can you just have him sign a document saying he's financially obligated to pay for stuff?
Return all property in his possession which belongs to the respondent and provide information of whereabouts if unable.
Yeah, perpetual joke, punching bag.
2. The respondent's request to produce in interrogatories. This request was sent to petitioner's counsel to further her evidence of ability to pay alimony by the petitioner to the respondent after finding information from the limited bank statement she received prior.
Yeah, and then the judge denied the motion, Sarah. So why put it in here again? The judge already ruled on this specifically, saying it's irrelevant, denied, but she's asking for it again.
In her itemized research and calculations with petitioner stating he was, quote, unemployed with no means of income, knowing from...
Why is unemployed in quotes?
Because he's not really unemployed. He's lying.
But
he's a liar.
But then he's stating a lie? No, he's stating something. He's not stating he was unemployed because it's in quotes, right? Unemployed doesn't really mean what it is.
Well,
does that make sense?
Yeah,
he stated something that's in quotes.
Yeah, if we're to take it the way it really what it would really mean is that he did say employed or unemployed because it's in quotes, so that would be quoting him.
No, but you would include was and in that
Yeah, of
sentence.
course,
You would
right.
include
Yes.
maybe include he was and put
But this
brackets
is
around he because
another
it's like
example of how she has no idea how to act. Like, you don't do that. You don't put sarcastic quote air bunnies in a letter to a judge.
no, but I think
Not that kind of thing. That's not, you don't do that.
good. So wait, Robin, can you settle this argument? I think sarcasm does help your argument. Like little quips and like little jabs, verbal jabs.
That's
And
not
sarcasm, I think that makes your argument stronger in a legal motion. Sumit seems to think it doesn't, but let us know.
Previous verbal statements he made to her, he was working, contract, and had been since her incarceration. The spending total did not suffice the income.
What about you, Sarah? You put on your thing that you have no income, yet you have expenses. And we know you don't have income because you're in prison. You're not working at all. That means you're getting money from somebody else, but you didn't list that, did you?
Petitioner filed an objection citing the timeline to submit their production was improper and the information respondent was requesting irrelevant. A second set of interrogatories was requested with no response.
Wait, yeah. Was irrelevant, and the judge ruled it was irrelevant.
And now this case in trial, the respondent is confused with the point of the objection, still waiting for judge.
Robin, can you tell us, do judges also like when you repeat things that you file as a motion and they deny? Do they like when you put it in a thing saying, but I still think this is the thing?
Is she has already been restricted access to this vital evidence.
Nah, he used plenty of sarcasm, but it wasn't disguised, right? It was a direct sarcasm, right?
There's also a difference between writing to the judge and in litigation.
It was a purposeful quotation saying, "Can you believe she said this?" Versus she is just doing sarcasm based on implied facts that don't exist.
Also, it's the kind of sarcasm. I mean, that quote thing that's so childish.
Right. I mean, good sarcasm. You read it and you go, "Oh,
right,
damn!"
You can make it. I mean, I know you were kidding about the sarcasm, but you can make a statement and kind of have an underhanded jab in there. But we're talking about quotes. That's a childish thing to. That's not. You don't. If you're going to put in quotes in a legal document, you don't do it sarcastically.
I think what happened. Here we go. This is probably what happened. Sarah, since her learning froze at 9th grade or 10th grade, right, learned that quotes implied sarcasm, right? But then never moved on to when you do actual papers and like research and you're quoting things.
She says it too.
And putting in there
and in quotes, was
she doesn't notice to put the supporting documentation, the reference for the case law right next to the quote. She's thinking of it like a 10th grade paper where you put the bibliography at the end. You list all the books that you had down there. But even in those papers, you still have to put the author's name and the page number.
No, anything.
You know how I know that? Because I always had to fake those when I would, you finish writing the paper because I hated English, right? Or whatever, right? I hated it. I hated writing up until a point. But in high school, I definitely hated it. And you would have to cite your resources, right? Well, I can't cite this because it's probably going to be called plagiarism, right? So you got to put the actual author's name, but then you put a different page in there and you don't put it in quotes. You're just putting it in the brackets behind because this is kind of an idea, not necessarily the direct quote of it. And I never would have survived today with the AI research. I'll just say that.
Yeah.
Not that I was plagiarizing my entire papers, but I was getting most of the information out of there. And I was like, I don't know. I got the point, the subject, the argument, and then the two commentary however paragraphs are phrased or formed, what they said, the conjecture, the evidence, support, commentary, whatever.
Of trial in her preparation for in full application of D. Any outstanding motions. All motions should have been heard or abandoned during the pretrial conference. A hearing for any motions other than for attorney's fees during trial request permission from the court. None,
Sarah? No outstanding motions, huh, Sarah? didn't you go blather on and on and on about your outstanding motion for contempt, where you said it's continued? That's an outstanding motion, you idiot. Do you not understand what outstanding means? Do you not understand?
She doesn't understand anything. Any 3-syllable letter that she wrote in this is not correct, or not even a word.
It's just funny where she chooses to put none, because she usually just vomits words everywhere, right? But she purposely puts none in the one section she should be writing something saying, look, I have an outstanding motion for contempt, and it's based on this and this and this and this. But she puts none. Even there, I couldn't help. I have to laugh. I'm like,
Narnia.
Request for judicial notice.
Well, that should be good. I can't wait to see what judicial notice she's going to ask for.
1. The respondent respectfully responds to the petitioner's request for judicial notice in their underhanded pretrial motion regarding notice of the...
Yeah, that should have been an outstanding motion. I'm an outstanding mother to my son. Yeah. That's outstanding, right?
How's that for a motion?
Quote, entire docket, end quote, of her criminal case.
Yeah, she did that earlier where she says none. And then immediately after the period, 2 spaces, continues to write a sentence and then several paragraphs after none. She doesn't do it here, though. God, she's stupid. First off, that is exactly. Yeah, okay. I stepped on it. I'll just read it here. Oh, let it play again.
Regarding notice of the...
I can't wait to see what judicial notice she's going to ask for.
1. The respondent respectfully responds to the petitioner's request for judicial notice in their underhanded pretrial motion regarding notice of the, quote, entire docket, end quote, of her criminal case.
I mean...
Underhanded.
It's underhanded, right? They're trying to get it into the back door, right? They're trying to slip the ace under the deck.
Yeah, how dare they ask for legal proceedings?
Sarah, basically everything you listed above is judicial notice of the civil case, which you should have listed here. But this is 100% what you would list under judicial notice. Hey, take judicial notice of the criminal case docket, just because it is what it is. It is the judicial record. It is in the court's own record. That's what judicial notice is for. God, she's stupid. First off, that is exactly what you would take judicial notice of, court records.
She firmly asserts her criminal file is irrelevant to this family law matter, other than the fact she has been incarcerated over a momentary time period, and with a pending appeal, the petitioner does not mention with opportunities for her proposed release.
Okay. Do you want to go first?
No, I'm not ready yet.
Okay. She says over a momentary time, as if it's past, right? No, she is perpetually incarcerated at this point. It is for all time until you are dead, Sarah. So it's not a momentary time. There is a pending appeal, and the petitioner does not mention, he doesn't need to mention that there's an appeal. You need to mention that there's an appeal with the grounds that it's going to be agreed upon, like something like, I have a pending appeal with the DNA evidence of the real killer that has been processed, and we're working our way with the governor, right? No, everyone appeals their criminal sentence, Sarah, unless you're Brian Kohlberger and you agree not to. But opportunities for her proposed release, just like there's a, so you're saying there's a chance. Oh my God! The petitioner
does not mention the opportunities for her proposed release. Why would he? First of all,
well, because he's scared of him.
And I mean, this would also be very stupid. But if she wanted to say something like some kind of stipulation where should her appeal go through and should she, then they can, some kind of like, which they'd probably be like, that's fine because you're never getting out, bitch. But but this
you're entirely correct.
Huh?
You're entirely correct. Yes.
Yeah, that's right. You know what? We'll call you when they let you out. But this is like, come on.
It should be like, look, I agree to all these stipulations, but if my appeal comes through, I would like to revisit them. It just like sign it like that. Be like, hey, look,
Yes.
I agree to this, right? But if my appeal comes through, I want to revisit this because that changes everything. You know what I'm saying, Sarah? Change in circumstance.
Yeah.
It seems like you're trying to argue for that, but you are also saying there is no change in circumstance, and that it's.
Also, the way she writes things, the way she words things, that's one of the things that makes it that the reason it took me so long to come to terms with all of the lies and just the way the petitioner does not mention with opportunities for her proposed release. That almost sounds like she's going to be released.
Right.
Like a proposed release. There's no proposed release.
Yeah. They're coming to, they're negotiating, right?
Right. That's not happening ever.
No, we're coming. You know, they want me to stay within a 30-mile radius. I would like 60-mile radius, right? And because I'm not guilty, and they're like, okay, well, you need to stay home confinement 24 hours a day. No, I would like 18 hours. We're negotiating here, right? We're negotiating.
She'd be better off saying, I don't think my criminal case has anything to do with this. I'm still a mother.
She does say that.
Yeah, I know, but she doesn't use that argument. She says,
right. Okay. Yep.
You know,
yeah, I got you.
She says it has nothing to do with it because she's going to be released. Her proposed release can be released soon enough. You know, so
well, not only she does not mention, she's saying that the petitioner and his counsel are doing legal malpractice by not mentioning the fact that she's appealing her life sentence, which is irrelevant because we're talking about changing circumstances. YouTube is decades old and still can't get notifications right. I agree with this DNA DOC 100%. I hate the notification system because no matter how much I click on something like, oh, this is coming up, I would like to know, it cannot notify me. It cannot notify me at all. It can notify me about all the other bullshit, but it can't notify me when I say, click, I want to, notify me on my thing. It goes, yeah, if you're in the app.
Mm-hmm.
I don't get it. How can you put push notifications for comments and everything, but you can't send a push notification for this show is starting?
I don't know.
Come on.
Issues
I don't get notified usually until 36 minutes after it started. I get notified. I mean, which I will even go beyond that. I will say when I'm in YouTube watching something and I have clicked notify me on another thing, you can't even give me a pop-up that it started in YouTube. I'm in your goddamn app. I'm on your website. You can't give me a pop-up saying, hey, this stream has started. What is wrong with that, YouTube? You can't give me a little pop-up in the corner saying, hey, this thing you wanted to see, it's there, right? You want me to watch YouTube, right? You want me to watch. So give me the notification of the thing I clicked notify me on. Jesus. God damn it.
My memory is shit too, which is why I would like YouTube to remind me of things, but they don't.
I have to use the little boy's room. I'm going to let it go.
For the court in this family law case pertain to civil obligations and rights, not, quote, criminal conduct.
Oh my God, this is good. All right,
the respondent's entitlement to alimony.
I'm going to let this play in the meantime while I use the little boy's room.
Oh God, what is it? It's not dancing, is it?
I was enough for her not long ago. I was her number one. She told me so, and she still means the world to me, just so you know. So be careful when you hold my girl. Time changes everything, life must go on, and I'm not gonna stand in your way. I loved her first, I held her first, and a place in my heart will always be hers. From the first breath she breathed, when she first smiled at me, I knew the love of a father runs deep. And I prayed that she'd find you someday. But it's still hard to give her away. I loved her first. How could that beautiful woman with you be the same freckle-faced kid that I knew? The one that I read all those fairy tales to and tucked into bed all those nights. And I knew the first time I saw you with her, it was only a matter of time. I loved her first, I held her first, and a place in my heart.
Place in my heart. No, this was the song he sang to his 13-year-old decoy. Well, I'm just explaining to those who are.
Sorry.
Here. He explained this to the 13-year-old decoy that he was. That have you seen the 5 different pictures of Kayla? Like,
I mean, I have, but I think.
Okay, it wasn't even the same person for 5 different photos, and he's like, "Oh, sexy little thing in the pool."
I mean, that's people. I mean, there's the woman in France who thinks she's engaged to Brad Pitt. You know.
Yeah. All right. Okay, we'll come back to the Sarah content.
Of contact and parental relationship and related relief arises from established legal principles in family law.
Yeah. Ladies and gentlemen, once again, Lorne Armstrong. Yeah, creepy. A pedo is singing a daddy-daughter song to an underage romantic. That's the whole point. The whole point is it is creepy, but he chose that song to sing. Like, he has no self-awareness. I thought you had blonde hair. Yeah.
Which are not negated by incarceration. Furthermore,
like, can you think of a more embarrassing song to sing as somebody being caught on decap? Like, in your like, that's what I said. This, it doesn't even have to be a minor child. You listen to his conversations in his chat log, and you're just embarrassed. You're like, oh my God, my friend is going down in flames. This is so humiliating. And the fact that it's to a child, when he's the one that's humiliated to what he thinks is a child, is even better.
Introducing criminal records into this proceeding serves no legitimate purpose other than to heavily prejudice the court, slander the respondent, and distract from the actual issues such as needs financially and parentally with lawful compliance and including.
By the way, we will be doing a Lorne stream. Maybe, I don't know, unless it's too late for Suma. I don't know how it's going for her, but
I mean, right now it's not that late. I don't think. I don't know. I slept nice and late because we were up so late last night.
Okay. Yep. We will be doing Lorne's life in a fart jar after this is the next episode. So
you know his car smells like masked fart.
Yeah, it smells like somebody said it smells like spoiled casino carpet, spoiled milk, and failure. Is Lorne's natural scent?
Desperation.
In the petitioner's continuous, vexatious, and strategic attempts to make their own rules, disadvantage the already disadvantaged respondent, with the unethical encouragement and direction of his counsel to do so, and how the respondent respectfully requests the court to take judicial notice of their entire docket of violations, contempt, advantageous exclusion of the court, and respondent intentional confusion.
How do you take notice of their violations?
While displaying an ongoing flagrant invincibility to any consequences for the continuation of, in the entirety of this family law case and all matters included. The court is respectfully urged to focus on and take under serious consideration all of the facts included in this case historically and relevant to the law, and disregard any attempts by the petitioner and his counsel to use unrelated criminal matters to sway its decision unfairly or
Sarah, you got it. The entire thing has to do with your criminal convictions. It's not unrelated. You cannot provide care for your son anymore, or else, you're not picking your son up anymore. What's the reason? You have to cite your criminal conviction, the fact that you're in prison, and the fact that you want to have your son brought to you every Christmas to spend mother-son day in prison where he has to sit there for 24 hours in the visiting area while you do your chores and your mopping and everything, or, visit your mom at work day, visit your mom in prison day, and he mirrors you. Like, Sarah, you cannot be this stupid. Well, she is this stupid, but this is bold. This is bold. Like,
it's not just stupid. It's not just stupid. It's her ego. Whatever I say this all the time. Whatever brain she might have, are completely crossed out by her crazy ego. Her
the fact that she brings up all the quote, unethical actions and the sanctions and whatever contempt that should be brought against Brian, right? All of that should matter, right? But the fact that she's already been committed of a crime is totally irrelevant.
That doesn't have anything to do with this.
Their unethical behavior in this case is the only thing that matters. Her murder charge in a separate issue is totally irrelevant. Like, Sarah, you cannot be serious.
Let's not forget that when she was out in the free world running around the townhome complex of Tealwood in Winter Park, she was a terrible mother. She very rarely met her parental obligations. I mean, just think about that when you look at this. It's just such nerve.
I want to get video for you. Extra.
Yeah, really awesome. Night night, termite.
Wait, want to get video for you. Extra.
Tell the officer what you want to be when you grow up.
Kathleen, where's the docket of their violation? Did you not pay attention to all the time she said they did the violation? That is gospel. That is gold. It is one random moment, but
it's not even about the suitcase anymore. Other than this whole suitcase thing, that was prioristically. That was way back.
Way back.
Yeah.
One random moment. Yes, it is one random moment. She had one moment of weakness where she was not perfect, like she always has to be, where she knows how to do 50 things and how to do the next 50 things. And what we are seeing here is Brian and his attorney continuously over and over and over slander, lies, unfairly, unlawfully punishing her for everything that she's trying to do rightly as a mother to her son, and something that is constitutionally guaranteed to have protections and the rights of a pro se person. But these idiots keep I can't keep going.
Lawfully, the respondent also respectfully requests from the court to take notice of the petitioner's payments described.
She still loves him the next day. She's there for him still.
Yeah, I'm here now because I
still love him. How many murderers show up next day to support their victim? Only Sarah. You can't point to anyone. Okay, you want that?
Send me money. Send me money. Send me money.
Yeah.
Oh shit! Clicked it again. I didn't remember where. Were we on? I think we're here.
As a direct result of these violations, making this case unfair and unequal, the respondent respectfully requests the court to deny the petitioner's supplemental petition to modify, as it would be unjust to reward.
Did we already hear this or we not hear this? Did I not go far enough back or am I too far forward? Everyone let me know. Do you know? It kind of all runs together. It's all the same bullshit.
I mean, it's very interesting because it's all the same, yeah.
Dishonest behavior and inappropriate example of the law. Sanctions for both the petitioner and his counsel should rightfully be applied in the favor of the respondent for such actions, in which she respectfully requests from the court in the conclusion of this case in family law matter. Citations.
Kin to Sukuroi. Just like to tsunami. I got flooded by a tsunami.
Or copies of any case law.
General Tusu chicken.
To be argued at time of trial. Please see each section completed per the uniform order with case law included for application in and of.
Well, we had it in the super clip rotation, and everyone complained. I don't know that anyone complained. Actually, no. They said they accused me of copying SKR when I didn't even remember that SKR on it. But SKR does premieres, so he doesn't do super chat reactions. He has to do his
I said that Sarah's face was doing Zumba, and someone told me that you said that, and I was like, really? I didn't remember that.
We can't believe these people anymore. You know what they're doing? They're turning us against each other.
G. Whether there will be a court reporter and/or interpreters in any agreement between the parties concerning the sharing of the cost of saying. The respondent requests to have a court reporter present to record, but due to her indigent status, has the inability to pay for. J. Good faith estimate. 1. A good faith estimate.
Taurus with me in my heart, in my mind, my body and my soul, as he and I used to say that.
Heard, understood in her explanations and truths, and considered in all aspects as does the petitioner, to maintain an equal level of the law and due process in her inexperienced and uneducated attempt to rightfully represent herself as pro se in this family law trial. In regards to a time frame for this to proceed, she is cooperative in any manner necessary for her full inclusion and opportunity in respect of the court's time and considerations. K.
It's fine with me, Carolina. I have no moderation on my channel. I don't know about Suma because you're on Suma's chat, but zero moderation on mine. And in fact, I just discovered adding people to the approved list. I added Suma, I added myself, I added Xeric, a few others, right? So we can say whatever we want.
You're saying she never sucked D's in high school or ever, probably. That's a compliment to her that I'm not willing to give.
She was just like, ew.
Yeah.
Can't. For making me feel what it is to be sodomized.
Yeah.
Financial affidavit.
Nobody wants to hear about him kicking in your back door.
I don't want to hear
financial affidavit for each part.
We don't want to hear about you getting your back door kicked in.
That's why we know that she peed on herself, and she just told us everything right there.
Shall be filed no later than 7 days before the pretrial conference. The respondent's handwritten financial affidavit was accepted by the court in the pretrial conference on May 29, 2025.
Yes, exactly, Robin. She can't name what the sanctions are because she, well, the sky's the limit, right? On a lottery, but I just want all these arguments to be ruled in my favor. But whatever you can do, Judge, however you can punishment, however badly you can punishment. Margarita, have you not seen the full sentencing statement? You understand this is a 17-minute clip.
Taurus with me in my heart, in my mind, my body and my soul, as he...
a 17-minute video on my channel. This is again where people don't look at the full video catalog.
We should start sending citations.
We really should. We really should.
No new financial affidavits will be accepted at or after the pretrial conference, absent good cause. End of uniform order and respondent's pretrial statement.
I feel like this is the same shit, but I'll just read it.
Supplemental petition for modification of final judgment. Inactive during respondent's incarceration of 2020 to present. Page 1, Item 3, substantial change in circumstances. A. Respondent became incarcerated February 2020. Petitioner seeking to modify shared parenting, terminate alimony, and child support. This document was filed over two years after respondent became incarcerated and has no judgment to date by the court. Final judgment and parenting plan open and active before and after this filing by the petitioner without any printed modifications. Per the marital settlement agreement, page 2, C, which, quote, shall survive the final judgment and be binding upon the parties for all times, page 2, D, quote, a modification or waiver of any of the provisions of this agreement shall be effective only if made in writing, signed by both parties and properly witnessed and notarized.
This is a substantial changes section, and she's listing out all the shit of like nothing can ever change, right? That's what the section is. Substantial change in
Never,
circumstances.
not even after the alimony is supposed to end, because now she can't get a job and support herself because she's incarcerated.
I think I made it through your whole catalog. I found you and was having withdrawals while you were on vacation, so I just watched everything. Oh yeah, did you see the?
Hey, thank you. Nice to have you here. That's all. That's all you have to do.
Oh no! My immediate reaction is to quiz. Yes,
I
thank
know,
you for watching the whole catalog. But did you see
Inside.
the video where the woman got klepto? I've klepto.
Send her
No
a
signature
quiz.
has been executed by the respondent on or in this inactive document.
But thank you. It didn't mean to denigrate you. I just want to do a quiz. No, but okay. See, not to be a kiss ass, so therefore it makes me think you didn't see the klepto
When
video.
she received via summons April 22, 2022, while at OCCD after not being included in prior filings to avoid being served in petitioner.
By the way, I did get a comment on maybe Hannah, maybe you put the comment on the video. It's called faking Parkinson's and
I don't think I've seen it.
and klepto. It's 2 body cam videos, and it's probably one of the more underrated videos on the channel. It's somebody that is pretending to be crazy at the beginning, but like it's like a fake Parkinson's when she murdered somebody, right? But she's just like doing how you would imagine faking Parkinson's, which is terrible. Or I mean, it's a bad acting. And then the second person is caught shoplifting, and then the cop is the greatest in that body cam because he's looking at the receipt. He's like, "Oh, what's the mug root beer?" She's like, "Oh, I need something to drink." And he's like, "So you don't have water at home? You don't have water? Okay."
Yeah.
And then like, "Oh, you stole it's just $30 steaks." And she's like, "We need to eat." And like, "Okay, but you couldn't have stole the cheaper steaks. You had to steal the top shelf ones." She's just,
I mean, come on.
or she stole a litter robot or a litter box that was automated. And he's like, "So the regular one wouldn't have do? Like you needed the robot one."
Yeah, she has kleptomaniaism.
Yeah, she has contracted klepto.
Accruing unnecessary
Yeah,
costs. This document has not been heard in court, nor a final judgment made. Has been
And then she's like, "Well, just let me go, with the warning." He's like, "Nope, I can't let you out. You've got klepto. You can't help it. you cannot stop stealing."
Implemented by the petitioner and his counsel, who willfully violated due process and standing court orders for over five years by refusing to acquire judicial modification and permission through formal proceedings. Page 2, item 4.
What do you think they're doing now, Sarah? These are formal proceedings.
Yeah, I still can't get over the fact that some asshole typed this whole thing out for her.
Yeah.
Modification of shared parenting. Discussed and proposed in Section B, the children of respondent's pretrial statement according to the Uniform Order. Page 2, item 5, termination of alimony. Discussed and proposed in Section C, alimony of respondent's pretrial statement according to the Uniform Order. Page 3, item 6, termination of child support. Both parties have mutually agreed verbally in court the respondent is not seeking to collect these payments from the petitioner. She's asking for the sum to be distributed to their minor son and for the respondent to be included in deciding how the funds should be used properly and accordingly. Page 3, item 7, attorney's fees and costs. Discussed and proposed in Section G, attorney's fees and costs of respondent's pretrial statement according to the Uniform Order. In addition,
the klepto stream link is in the chat there. Don't watch it now.
In conclusion,
so when you rewatch,
would like to reiterate to the court that she has been proactive, eager for involvement, proposed numerous solutions, and cooperated in every manner with the petitioner, its counsel, and the court since the beginning of this case. Going to trial is a direct result of their egregious decisions to be non-compliant with multiple court orders, which could have been avoided from opportunities to collaborate, simplify, even conclude this matter prior to save time, money, effort for all parties, the court foremost. The respondent should not be responsible for the petitioner's perjury, self-confusion, and lack of ability to maintain their manipulative attempts to strategically sabotage her in this family law case and in their poor examples of professionalism, ethical practices, lawful and respectful treatment of the respondent and the court. The respondent is profusely grateful for the court's invaluable time, patience, understanding, and seeing her ceaseless good faith efforts and determination in achieving rightful success in her son's life, lawful obligations, her appeal, and productivity moving forward, regardless of time, location, or circumstances.
Okay, and then the next page shows Joshua Martell's address. So I missed the part where she said it, but she's like, they just should not be applied to the payment. So I'm glad I covered it earlier, which that is his dumbest argument, because you want him to have been making payments towards alimony, even if it was insufficient, right? He's making partial alimony payments, recognizing that he owes the debt, but she wants to get more money. I'm not going to put that in there.
Or at least just to help her out, like just to show that that he's not, whatever.
Yeah. But she says that she gave him a copy, that she swears she gave him a copy. And then she includes the original copy of her motion for contempt. Well, that was just simply great. I'm going to go ahead and highly doubt that in any of these cases she lists here show where somebody was incarcerated for murder for the rest of their life and then they were continued to be ordered to receive alimony. Just off the top of my head, I'm guessing that isn't there. There might be a case where somebody was in prison and was still lawfully required to provide support, which Sarah would think, oh, it's the same thing. You know, definitely prison doesn't change any support agreements. Well, that's because the person going to prison did that of their own action. And that is the end of the sentencing statement.
The other thing that I just want to mention, we may have talked about it yesterday, I don't remember, but she talks in the beginning of this, you know, way back, the beginning of this letter, she talks about, about how they didn't come see her or something for 7 months. And it was the 7 months, for the last 7 months, it was the 7 months that she was being relocated. They couldn't. Mm-hmm. And she thinks that no one's going to figure that out. Like, I hate her.
So I was laughing at the comment. Yeah, okay, I got to get better at the playlist updates, but I thought it was in the Bromos playlist. I don't know. That was actually the first video to premiere the Bromos intro, or at least the partial idea of the Bromos intro. But yeah, you're exactly right. The 7 months, it's because of her.
Yeah, because she's incarcerated. They were switching her from jail to a facility, her forever home. And she's acting like, you know, as if they could just come see her. And
So we are going to now move over to the Lorne stream, which again, we're getting more and more converts. Everyone is discovering the magic of Lorne. I think you need to put it in your channel. You should put it in your chat too, Suma. Let me put it in the background so you can paste it in there, because I don't think what I paste in my chat, or I don't think people let me know when I'm pasting in my StreamYard chat is not showing up on Suma's channel, I don't think. But here's the link there, Suma. Background. So we're going to be listening to Life in a Fart Jar, Lorne's Life in a Fart Jar, which is just, it's another chapter. He is an acquired taste, but the more you taste it, the better it gets. Because that sounded horrible. Because the worse he is, yeah, he's great for laugh. The frustration we feel with Sarah, Lorne is the peak for laughter because he is so pathetic. And like I was telling Suma, the stream today had him talking to Jamie, being jealous about the chat rooms that she was supposedly in, but he made up the jealousy himself because he just said, he sent a text saying, "Are you in a chat room?" and she didn't respond, saying no. So therefore she was confessing. Yeah, and he's prevented from hurting kids. He never actually got to hurt a kid that we know of. So, I just have my theories about what his fantasies were. He has a lot of fantasies, but he doesn't have actual victims because he's so stupid.
Yeah.
Internet chat rooms. That's right. NWAW skeptic. Oh, great. So I will see you over there. Yes.
Yes.
Wait, where'd my outro video go? Outro says, oh, I get it because I changed it on this one. Okay. All right. We will see you there in momentarily. You should be redirected, but if not, go ahead and well, Kelly, yeah, that's a much simpler question to be answered than it is in this short time here, but we can continue on the next stream. Okay, we will see everyone over there. All right, bye. God, she's stupid. First off, that is exactly what you would take judicial notice of. Court records. Halfway through the 20th page. It's going better than I thought it was going to be. Taste the Rockies. Oh, there goes the cap. I don't want to kill you. Do you feel in charge? No, brother. They expect to find a body. Rock, flag, and eagle. Red eyes, black eyes like a doll's eyes. Don't seem to be living till they bite you. Those multi-syllable words were difficult at the end. Throw a little chaos in the mix. This unsung hero of Gotham. You can't rob the stock exchange. There's no money here. Why are all you people here? We're going mobile. All right, let's go.